The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori, good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Lawgic, with a special early breaking news edition of the following program. So first and foremost, I need to apologize to those of you who are not following me on locals and were unaware, which I guess if you're not following me on locals by now, can't really I'm not exclusively to blame in this relationship. But I have been under the weather for the last several days. I'm finally getting my voice back. My voice is like 90% where it is. I may have coughing spasms still. I was dealing with a pretty bad flu. I still don't think it was COVID. Never went to a doctor. I think I'm totally fine now. But I just wanted to apologize. This is the longest. I think this is the biggest streak of days I went without producing a regular show. I was on locals earlier today, and while I was on locals, this story broke. This story specifically that the Colorado Supreme Court has issued a decision whereby they are barring President Trump from appearing on the ticket. They've stayed their own decision in anticipation this is going to be taken up by the Supreme Court, which is astonishing. That too is astonishing. And frankly, if this decision holds, one can make a very strong, a very compelling case to say that this may be the most significant decision issued by a state court, an individual state court in American history. It's hard to argue it's hard to think of anything that would come even close because the ramifications of this decision and the ripple effect it can have throughout the rest of the country, the ripple effect it can have on the culture, on unrest in this country, which I certainly hope and pray it doesn't cause any civil unrest in any way that is outside the bounds of what is permitted under American law. It's not crazy to have concerns about the ramifications of this decision. Because the Supreme Court barring former President Trump from being able to run in Colorado, we have to imagine that if this stands, which we don't know that it's going to stand, but that's the law in Colorado as issued by the Supreme Court. If this stands, the ripple effect will be felt throughout the entire country. And the impact this will have on the attitudes and perspectives of tens of millions of Americans is just astonishing. And frankly, I have very grave concerns that this can only deepen the divide that we have in our country. This is supposed to be some sort of cure. That's what this is supposed to be. That's how this is being painted to us, is being portrayed to us. This decision, even if it's reversed, has only driven a stake into the divide. Because now, if it's reversed, the assumption is going to be that, it's reversed because the Republicans love Trump or some twisted perspective like that. We're going to go through the decision. I have not yet had an opportunity to go through it. I first discovered this decision roughly an hour or so ago when I was covering locals. We're going to read through it, and it's a lengthy decision. So it's going to take a while. But I'm going to try and do it in expedited attorney fashion. So this way I can give you my perspectives and sort of give you the entire lay of the land as viewed through the lens of an attorney. And hopefully that will help you get a quicker view while having a complete and comprehensive understanding as to the rationale of the Colorado Supreme Court. With that in mind, proceed. All right. So, as I said, this is a lengthy decision. It was issued to December 19th, and this appeal from the District Court proceeding on the Colorado Election Court. The Supreme Court considers whether former President Donald J. Trump may appear at Colorado Republican presidential primary ballot in 2024. Okay, and a Supreme Court case, caption, who the attorneys are, very official looking, very important, very significant, per curiam. So this was a 4-3 decision. The dissenting judges, it's weird that they put the dissenters down over here where they have the attorneys, the judges who issued the decision. Honorable Sarah B. Wallace is the original one, respondent appellee. Here are the petitioners responding, because Jenna Griswold was the one who was sued, and there were two interveners. The interveners were the Colorado Republican State Central Committee and Donald J. Trump. By the way, I streamed this entire trial. I'm the only attorney I know of that did stream this trial. If you want to go back, you can see those streams. I believe that they're still available for public viewing. But that's why I feel like I have a more intimate knowledge of this case than I think most attorneys who are going to be handling this. The Colorado court woke up today and clearly chose violence. I'm concerned about this. I'm going to repeatedly urge throughout this live stream not to engage in violence. Not to engage in violence, but this does seem to beg for violence. It's to those who are not going to hearken to my voice, because I'm very sincerely telling you that if people engage in violence, that will make things worse, not better, worse. Just like the violence from January 6th made things worse, violence at this stage is almost definitely going to make things worse. Should people be protesting? Absolutely. Screaming their lungs out? Absolutely. In compliance with laws? Absolutely. I want to be crystal clear on that. And I'm not saying that purely because I'm on YouTube. I'm saying that sincerely because I think it would be strategically moronic to engage in violence at this point. Like stupid. Absolutely stupid. More than 3 months ago, a group of Colorado electors eligible to vote in the Republican presidential primary, both registered Republican and unaffiliated voters, filed a lengthy petition in the District Court of the City and County of Denver, asking the court to rule that Trump may not appear on the Colorado Republican presidential primary, invoking provisions from Colorado's Uniform Election Code of 1992. Electors requested the District Court prohibit Jenna Griswold, in her official capacity as the Secretary of State, from placing Trump's name on the presidential primary ballot. Their claim was that Section 3 of the 14th Amendment to the U.S. Constitution disqualified President Trump from seeking the presidency. So first and foremost, you have to ask yourself, one of the questions that's being asked from the get-go is, how is this a state court issue if you're saying that he's disqualified in the 14th Amendment? Well, if that's the 14th Amendment of the U.S. Constitution, that seems to be an issue of federal question. When it's a matter of federal law, state courts have no subject matter jurisdiction. They cannot weigh in on that. Somehow they managed to, the court, both at the district court level and apparently at the Supreme Court level, decided we're not really worried about that. More specifically, they asserted that he was ineligible under Section 3 because he engaged in insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. After permitting Trump and the Colorado Republican State Central Committee to intervene, District Court conducted a 5-day trial. Ooh, a 5-day trial. A 5-day trial. The court found by clear and convincing evidence that President Trump engaged in insurrection, as those terms are used in Section 3, which that finding was rooted largely on the J6 committee report. Despite the fact that there was tons of evidence as to how one-sided and how it was predetermined in the report that they were going to label him as being guilty of insurrection without doing any actual investigation before they began their investigation, well, we still take this as being gospel. Despite tons of evidence that there was plenty of omissions purposefully left out that exonerate him. We don't care. But District Court concluded Section 3 does not apply to the president. Therefore, the court denied the petition to keep President Trump off the presidential primary ballot. So what they basically said, what the District Court said was, we find that he engaged in insurrection, but we don't think that Section 3 of the of the 14th Amendment applies to the president. The language of that section of that portion of the Constitution seems to, by most accounts, purposefully omit. And since this is something that's going to come up frequently today, should pull up the 14th Amendment, Section 3. This is not good. I can't be dealing with you for 2 hours. I'll pull this up now. 14th Amendment says no person shall be a senator or a rep in Congress or elector of a president or vice president, or hold any office, civil or military, on the United States or under any state, or having previously taken an oath as a member of the Congress, office of the United States. So when they're going through the list of people, positions that you cannot hold, and if they did what? If they were a member, if they took an oath to support the Constitution, and they shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So, no person who previously took an oath as a member of Congress or as an officer of the United States to support the Constitution. So, those are the key parts here. I've previously taken an oath. What's the oath? To support the Constitution. And then after you take that oath, you engage in insurrection or rebellion against same, or give aid or comfort. So they're claiming that after he took an oath to serve as president, that he then breached that oath. Therefore, he cannot be, this amendment does not permit him to be president. Now, what offices does this seem to bar? It doesn't say you can't be president. It says you can't be a senator, can't be a representative in Congress, can't be an elector of a president. It's not like they forgot that the president was there. They say you can't even be an elector of a president. They seem to almost purposefully omit president and vice president, which is a very strange language. The argument that was made by the court or by petitioners and seemingly was accepted by the Supreme Court of Colorado is that that still applies to president. Okay. The electors and President Trump sought this court review of various rulings by the district court. We affirm in part, reverse in part. We hold as follows. The election code allows the electors to challenge President Trump's status as qualified candidate based on Section 3. Indeed, the election code provides electors the only viable means of litigating whether President Trump is disqualified from holding office under Section 3. We'll see what that means. Congress does not need to pass implementing legislation for Section 3's disqualification provision to attach, and Section 3 is, in that sense, self-executing. We'll talk more about that, because one of the big issues that came up is this statute self-executing? In what circumstances is a Secretary of State able to basically come to reach a conclusion on his or her own to determine that, Section 3 of the 14th Amendment bars this person? Like, how does that happen? And there was plenty of testimony about situations where the Secretary of State says, hey, look, you're not of proper age. You're barred. You're not a citizen. You're barred from running. Over here, they're saying, well, it's self-executing. Okay. I guess it's self-executing if someone's an insurrectionist. Okay. They also find that judicial review of President Trump's eligibility for office under Section 3 is not precluded by the political question doctrine. Okay. There's a lot of findings here. All of these, by the way, any one of these findings, that if they had found any one of these in Trump's favor, case is done and he's on the ticket. So look at all the boxes they had to check off, finding against Trump completely independently, not motivated by politics at all. No, they had to independently come to the logical assessment on each of these. And he happens to be, how many issues are there here? 1, 2, 3, 4, 5, 6, 7, 8. 8 No, Trump's 0 for 8. If he had been 1 for 8, he wins, but he's 0 for 8. Surprise, surprise. This is obviously completely fair. Completely fair. Phil Collins says SCOTUS is now in Alinsky. You're trying to say Saul Alinsky-ish. Alinsky decision dilemma. Do they let this ruling stand and destroy their credibility, or do they destroy their credibility by protecting Trump? See, I don't really think it's really that. I don't really think it's that bad, because so many courts already rejected this claim. It's not like Colorado's the first state to jump in there. They're like the fourth state to jump in there, and the first one to say, oh yeah, this is our place to do this. They're the first ones to come up with this. So in that sense, Colorado, much like when it comes to like permitting weed, they're the first ones to jump out on the I think they were the first state on that to legalize weed. They're the first ones in the pool here, where others have dared to tread. So it's not that much of a limb for the Supreme Court to step out. Yeah, it is just the 14th. They just give a random list of people. There wasn't anything. Thank you, Billy. I appreciate your support. Little Rock, 9 months. I thought it's been years. Yeah. You can up your membership, Little Rock. You don't have to keep it. You can come up to like high priest level. Prophet level. It's good to see you, though. I'm going to give you one of these just because see your face. Remember the following. Following is not a cult type of cult. Members are called followers, but they're not followers of me because I'm not the leader of this cult. That's not a cult. I'm just a follower, just like the rest of you, just like Little Rock, just like you could be. Wow, my voice is going to struggle tonight. I want you to know, when I was sitting there doing this on Locals, I'm sitting there and I'm like, what should I cover tonight? What should I cover tonight? I don't know. I'd really rather watch something that I can like rest my voice for 30 to 40% of the time. But don't worry, I got plenty of coffee. That's certainly going to help my voice. Okay, so what else did this esteemed court find? Section 3 encompasses the office of presidency and someone who has taken an oath as president. On this point, district court committed reversible errors. So we're reversing the court to the extent that she found in favor of Trump, that when they say that office of presidency, that when it says over here in the 14th Amendment, hold any office, that includes office of presidency, even though obviously it's listed like 5th on the list here. Oh, doesn't matter. That's where, of course, you would throw the president in. The district court did not abuse its discretion in admitting portions of Congress's January 6th report into evidence at trial. Of course, it's not abuse of discretion. District court did not err in concluding that the events of the United States Capitol constitute an insurrection. Meaning, here's another question. Is that engaging in an insurrection? How on earth is that engaging if he's talking? Is incite, even if he did incite, which it's kind of a violation of Brandenburg to find that he incited. It's kind of ignoring Brandenburg to find that he incited. But even if he did incite, is incitement, if he had actually incited, is that engaging in insurrection? Well, apparently the court did not err in concluding that. The district court did not err, including President Trump engaged in the insurrection through his personal actions. Oh, okay. And President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6, 2021 was not protected by the First Amendment. Oh, this is going to be really interesting. It's not. Oh, okay. Apparently, every district attorney before assumed, even the ones who hate him, all assumed that it was. But Colorado Supreme Court, 4 justices on the Colorado Supreme Court, they're like, no, we're not breaching his First Amendment rights at all. The sum of these parts is this. President Trump is disqualified from holding the office of president in Section 3 because he's disqualified. It would be a wrongful act in the election code for the secretary to list him as candidate of president primary ballot. So here's our little summation for you journalists who don't like reading 100 pages. So here's our sum. Here's your summary for you to put in that you should clip out and run across flash across those screens right now. We do not reach these conclusions lightly, and no one should think that we're throwing a party here. please don't Please don't get fooled by the sound of loud music and the clinking of champagne glasses. We are mindful of the magnitude and weight of these questions now before us. We're mindful of our solemn duty to apply the law without fear or favor, without being swayed by public reaction to the decision that the law mandates we reach. We're cognizant that we travel in uncharted territory. Oh, okay. That's nice. And that this case presents several issues of first impression, and that we happen to be finding all of them against Trump. That's what's so astonishing. There's so many issues of first impression, and they're like, and on this one you lose, and on that one you lose, and on that one you lose, and on that one you lose. And if he had won on any of them, he wins. Unbelievable. Little Rock. This present for me to be able to catch you live. Work on prep for trial early in the morning. Took break to listen to one of my favorite YouTubers. I thought I was high priest level. Are you? Okay, now I got to check up. Are you high priest level, really? You might be. God bless you, brother. I don't think so. I only had one high priest. God bless you. And good luck tomorrow in your trial, brother. Mary Cedar Rose. Remember the following, become a YouTuber. Should I check up and see if you're... I want to salute you again. I appreciate it. All right. So we're cognizant we're traveling in uncharted territory, and we're venturing out into this wilderness here and hacking through all new uncharted territory and somehow landing in paradise where Trump is barred. Before our resolution elect his challenge on the election code, the Secretary will be required to include President Trump's name on the 2024 presidential primary ballot. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. We're going, folks, we're running to the Supreme Court now. We are running to the Supreme Court. Wow. That's what's happening. This is crazy times we're living in. Crazy times. If review is sought in the Supreme Court before the stay expires on January 4th, then the stay shall remain in place. And the Secretary will continue to require or include President Trump's name on the 2024 presidential ballot until the receipt of any order or mandate from the Supreme Court. So at least the court here has sufficient humility to say that we're not knocking him out. As long as you go and make your application to the Supreme Court by January 4th, and there's some sort of pendency of that application, in that case, we don't want you knocking him out. You can always knock him out later. Let him stay there until such time as the Supreme Court comes up with their decision. And we don't have so much arrogance that we're going to tell the Supreme Court, you have to issue a decision on this by January 4th because Colorado Supreme Court said so. So, because that's not likely to make them happy with us. If we say, hey, you got to stay in for Christmas, Justice Alito. Hey, Justice Roberts. No New Year's for you because Supreme Court needs you to issue a decision. Otherwise, they're basically they're changing American history forever. It's not the sort of thing that's going to find favor with the Supreme Court. On November 8, 2016, President Trump was elected as the 45th president of the United States. Okay. Served in that role for 4 years. November 7th, 2020, Biden was elected as the 46th president of the United States. Okay. I guess that's their finding of fact. Trump refused to accept the results. Biden now occupies the office of president. Okay. On December 14th, Electoral College officially confirmed the results. 306 votes for President Biden, 232 for President Trump. I need one moment here. Sorry, this may happen a couple of times here, but just a health thing. Give me 1 second. Okay, that's much better. On December 14th, the EC confirmed the results. Trump continued to challenge the outcome. On January 6th, something happened. Pursuant to the 12th Amendment, Trump held a rally that morning at the Ellipse, at which he, along with several others, spoke to the attendees. In his speech, which began around noon, President Trump persisted in rejecting the election results, telling his supporters that we won in a landslide, we will never concede. Urged his supporters to confront this egregious assault on our democracy. Walk down to the Capitol and show strength, and if they did not fight like hell, they would not have a country anymore. Before his speech ended, somehow they missed out the whole peacefully and patriotically. Interesting. They're like the only ones in the country who missed it. And show strength. This is not at all like every other political speech in history. Before his speech ended, portions of the crowd began moving toward the Capitol. Below, we discussed additional facts regarding the events of January 6th as relevant to legal issues before us. Just before 4 a.m. the next morning, Vice President Michael R. Pence certified the electoral votes. President Trump now seeks the Colorado Republican Party 24 presidential nomination. Now, I will give him credit on one thing here. There's one thing I'm going to give them credit on. They don't mention the attack or the siege or whatever you want to call it. They don't mention that, nor should they. Because if you're analyzing, when a court is analyzing whether or not he did something, you look at what he did at the time that he does it, and you judge that standing in a vacuum. So I credit this court in that they didn't say, and the result of that was these people went and broken the barricades and stormed the paratroopers and overran the stormtroopers and got out their lightsabers, and there was a whole choo 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 going on in the cat. No, none of that's relevant. It's what he did. Is that a crime or is it not? So I give him credit that while their perspective of things that they say here is retardedly skewed, at the very least, they have sufficient legal acumen to recognize that whatever happens between then and after that doesn't matter. Doesn't matter. Okay. They also don't mention anything about what he said leading up thereto, which is an interesting thing. Meaning, they don't talk about all the tweets and the background, and the context, and the other stuff. They don't analyze on the stuff that happened, which at trial, the district court thought this was terribly, terribly, terribly important stuff. That what he was tweeting in October of 2020 was very important. And like even before the election, what he was writing in the summer of 2020 was very important for priming January 6th. And certainly anything he tweeted in November and December, oh my God, that obviously is highly relevant to whether or not he somehow engaged in insurrection. That's what the trial court found. When they're doing their analysis here, all they're focusing on is what did he say? What happened on January 6th? What did he do? What did he say? These words, that's the problem. So they're reaching a conclusion, which is not at all what the trial court rooted her findings on. Because they're so bad, like convoluted in how they come to this thing. On September 6, 2023, electors instituted these proceedings against Secretary of Denver District Court on their actions. In their petition, they challenged the authority to list President Trump as candidate. Trump intervened, almost immediately filed a notice of removal to federal court, saying, why the hell are you in state court? This is an issue of federal question. We'll try and interpret the 14th Amendment here. What the hell's happening? In light of the removal, Denver District Court closed the case on September 8th. On September 12th, federal district court remanded the case back to state court, including that elect jurisdiction, because the electors had no Article 3 standing. The secretary had neither joined nor consented to the removal. So because they had no standing, so that means now it's not a matter of federal question? Really? That's interesting. Okay. Just because they don't have standing doesn't mean that it's still properly litigated in state courts. Once the electors filed proof with the district court that all parties have been served, court reopened the case on September 14th. Glad you're alive, Joe. Welcome back. Happy belated Hanukkah. And what a topic for the return YouTube stream. Yeah, my God, this is crazy. The Colorado Supreme sees themselves as colonizers, hacking into the legal wilderness. Yes, apparently they are. They're colonizing this terrain of legal marshes, like Cortez or something. Come to Florida. Okay. Pin your next comment. Try and get you on Timcast 811. 811. Pin my next comment. 811. Gotta find your next comment. I'm gonna pin your next comment. You're not able to do that. You're not able to pin it yourself. Try to get me on Timcast. It should be on Timcast. I'm the only attorney who actually covered this stupid trial. That retarded exhibition. But he does whatever he does. Ultimately, everything's in God's hands. If I'm gonna pin your comment, I gotta go in here. Everything's in. There you go. Thank you. Much obliged. You're a great mod. Thank you, brother. Trump refused, didn't even show up for the inauguration. Yeah. How is what Trump did any different from what Gore in Florida in 2000? Oh, because he gave a speech where he said we're going to fight. Didn't you know he spoke? He gave a speech where he said he's going to fight. You made an excellent point. This is all theater. They're trying to incite the masses to prove the right is the party of violence. None of this matters until and when Trump asks SCOTUS to figure it out. Oh yeah, I'm telling you right now. And this is why I started off at the very outset here saying, when I say this has potential to incite the tens of millions of people, I think it definitely does, and I pray it doesn't, if for no other reason than that it is literally like stabbing ourselves in the chest. If people become violent because of this decision, it will be so self-destructive for anything MAGA related, and it will only lead to greater and greater clamps. It'll be bad for me and my freedoms if people become violent. It will be bad for you and your freedoms if people become violent. This is not a moment for violence. Not at all. And if people, God forbid, go down that road, just like January 6th ended up harming Republicans in an infinite number of ways, this has potential to be worse. So, yeah, I agree with him totally on that. All right, let's move along. Once the electors file proof of the district, the party's been served. Okay, the court set the matter down for a 5-day trial. Parties input. Court issued expedited case management deadlines. Host of matters, including disclosure of expert reports, witnesses, etc. On October 11th, Secretary's office received Trump's signed the notarized statement of intent to run as candidate for president. The approval form for him to do so signed by the chair of the Colorado Republican Party. Yeah, that's a great point. Thank you, Purple AJ. If you go to protests and you see anybody promoting violence, understand this: 97% chance that is a Fed. Okay? You shout the person down as being a glowy, okay? And start screaming Fed, 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 Fed at that person. Almost definitely. That should become like a new mantra. Fed, 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 Fed. Mock the guy out of there. On October 20th, District Court issued an omnibus order addressing many outstanding motions. Regarding President Trump's motions, court reached 3 conclusions that are relevant. 1, electors' petition involved constitutional questions, but remained a challenge against election official based on alleged duties. Oh yes. Somehow this is okay. And such a claim was proper under Section 113 as a matter of procedure. Okay. So Is it proper to be the first ones, even if it was such a, to be the first ones to explain what the federal, what a federal statute means? It's bizarre. Meaning, this is the point I want to get to. Okay, this is one of on this particular issue. Sometimes there's going to be this sort of murky area between state law and federal law. This is not the first time this has happened. This comes up frequently. But in most cases, and we understand that state law is not supposed to be interpreting federal law. In most cases, even if there's an issue that's related to federal law, the state court has the ability to look through a litany of cases which have decided the issue on sufficiently relevant points. They can sort of say, okay, look, we're not a federal court, but we can sort of understand how the federal court would almost certainly find here based on their history of how they dealt with this matter. So in that area, in that instance, you can understand why state court would be like, look, we understand it's not an area supposed to do it, but this does come into our zone. And there's so much federal law that we can look back at and says, this is how this statute gets understood and interpreted and explained, blah, blah. And this is how it gets applied. And here's a 3-pronged test that we will follow. So, they could sort of lay out how things, if they want to have, here's a great point, a great example. Okay. Let's say a state court is trying to figure out whether or not there's a incitement, someone engaged in incitement. So this incitement is a freedom of speech issue. It's a First Amendment issue. You might say, how can a state court sit here interpreting what incitement is? How are they going to do that? Well, you want to know why? Because it's their state law that they're applying, and they're reliant on a thick body. I'm talking like this is like, some hideous orca body of First Amendment law. Okay, I mean, just picture, like that Jabba the Hutt girl type of body of case law when it comes to incitement. That's what we got going on there. So if a state court is trying to figure out, well, how do courts look at the First Amendment and apply Brandenburg? They got the whole standard. They got all these different, they got this whole huge, massive body of case law. And they can look at how it's applied by the Supreme Court, how it's applied in our circuits. And then you sort of come to some sort of thing like, this is what the federal court feels about this. So when we're applying this over here in our state issue, we can come to it. That's completely different from, as this court admits, hacking into the wilderness of something never decided by the federal court. And you know who's the first ones to decide it? The Supreme Court of Colorado. Like, who do you think you are? Who the hell do you think you are? Like, the complete hubris to think that there's 3 different issues that no federal court has ever tried to figure out what this statute means. We're gonna be the first ones. We're just gonna venture on out there. We know we got what's going on now. I know what's going on. I got this. This is a definitive statement. It's so stupid. This is like, you have to be woke to think that. I mean, I guess maybe not everyone is arrogant as woke, but my God, such an embarrassing character flaw. Shout from the mountaintop, all violence portrayed to be perpetrated by the right is a fed up. I'm so mad about this. Even my state of Michigan even said, yeah, screw that. I could rant all night. Yeah, you should. And you should. I'll give you one of these just so you feel like your rant got totally validated. There you go. If SCOTUS rules that Trump has executive privilege in the Colorado ruling, is the Colorado ruling, you said mute, but you probably meant moot, M-O-O-T. Or if SCOTUS rules Trump didn't participate in insurrection, would the ruling scuttle the D.C. and Georgia? Probably. Those are 2 different questions, right? So executive privilege likely would knock this off. It's an interesting question. Executive privilege. They might try and they not might. They certainly will try and slice that baby to say, well, he has executive privilege in this. I don't know. There's way too many different formula as to how this and variables that are playing in here for me to tell you that it really would depend on how it's worded by the Supreme Court. It really would depend on how it's worded by the Supreme Court. Also, I'm not all the way through this decision yet, so I can't tell you. Yeah, but to assume that the Supreme Court decision on executive privilege, or saying that he didn't participate in insurrection, is going to be relevant over here, I think that that's a very safe assumption that it's going to be highly relevant. But I can't tell you definitively before I read the rest of the decision and hear what the Supreme Court says, because how the Supreme Court words it is going to be everything. You know, it's good. It's a good point. So, thus, because the electors had alleged such an act, so 113 does not limit challenges to the acts that have already occurred, but rather provides for relief when the Secretary is about to take an improper or wrongful act. Because the electors had alleged such an act, the matter is ripe for decision. It couldn't conclude as a matter of law. The 14th Amendment excludes a candidate from the presidential primary ballot, or that a secretary has the authority to determine the qualifications. Regarding the CRS, Colorado Republican State Committee's motions, we're just going to call it I'm going to call this, when we see this, Colorado GOP. That's what this is. This is what this is. Regarding the GOP's motions, the court in relevant part concluded state does not violate a political party's First Amendment associated rights by excluding a constitutionally ineligible candidate. So if you're constitutionally ineligible, keeping them from running is not a violation of their rights. But also rejected the GOP's argument that to the extent it purported to raise an independent constitutional claim beyond the proper scope of Section 113 proceeding. And then Trump joined in, asking to exercise asked us to exercise original jurisdiction to halt the scheduled trial. He came to us directly. He said, why the hell are we having a trial here? You need to rule as a matter of law that that the district court is out of their lane. 4 days later, we denied the petition without passing judgment on the merits of any of Trump's contentions. October 25th, district court denied Trump's 14th Amendment-based motion to dismiss. As relevant now, court concluded that it would not dismiss the case under the political question doctrine, but it reserved the right to revisit the doctrine to the extent that there's any evidence or argument at trial that provides court with additional guidance on whether the issue of president eligibility has been delegated to the United States Congress. Okay. And whether Section 3 is self-executing is irrelevant because Section 114 allows the Secretary to exclude constitutionally disqualified members, and states can and have applied Section 3 pursuant to state statutes without federal enforcement legislation. So we don't need it to be self-executing in order for us to stop our Secretary of State from putting the person on, which sounds to me to be absurd, but we'll see what they say on that later. And 3 would reserve for trial the issues as whether Section 3 applies to the president, whether President Trump engaged in insurrection. The trial began on October 30th, and you watched it right here on Good Lawgic. The evidentiary portion lasted 5 days with closing arguments almost 2 weeks later on November 15th. During those 2 weeks, the electors, the Secretary, Trump, and the GOP submitted proposed findings of fact and conclusions of law. The court issued its written final order on this November 17th, finding by clear and convincing evidence that the events of January 6th constitute insurrection, which is really an extraneous fact because that's not part of what he did. But President Trump engaged in that insurrection, I guess, somehow, okay. And the court further concluded, however, that Section 3 doesn't apply to president because terms using Section 3, the presidency is not an office under the United States. And this is a distinction for those of you who may have missed parts of that trial. This is a key distinction which came up during the defense's case, which is basically talking about when we look at this 14th Amendment and what the petitioners basically alleged is when it says hold any office, no person, and then later on it says, if you were as a member of Congress or as an officer of the United States, meaning at the time that you took an oath as a member of Congress or as an officer of the United States, is a president an officer of the United States? And and what the point is, or is he the office of the United States? Meaning, I, as an attorney, like all other of my brethrens in law, are considered officers of the court. The judge is not called an officer of the court. The judge is called the court. So when you talk about an officer of the United States, he is the office. He's not an officer of. That's what the defense argued, and that's what the district court agreed. This court doesn't seem to strike that conclusion. Nor is the president. So he's not an office, and he's not an officer of the United States who had previously taken oath to support the Constitution of the United States. Accordingly, Secretary could not exclude Trump's name from the presidential ballot. That was what the district court found. That engaged, that this was an insurrection. His incite, he did incite. That incitement is an engagement, and that if we were talking about any other office, so he can't run for senator. If he had been a senator, he wouldn't be able to run for Senate. But because he was president, and now he's running for president, Section 3 of the 14th Amendment does not apply to him. Ooh, Steve Gosney rating me. God bless you, Stephen. How are you, my friend? Good to see you. On November 20th, both the electors and President Trump sought this court to review a district court rulings under Section 1, accepted jurisdictional of the parties' cross petitions, and here we go. So that's how we got here now. That's where we're all at. Meaning I guess they skipped, I'm sure there's an intermediate level for appeal in Colorado, but they came straight here and we said, let's roll. Let's roll. We begin with an overview of Section 3. We then address threshold questions regarding 1, whether the election code provides a basis to review electors' claim, 2, whether Section 3 requires implementing legislation before its disqualification provision attaches, and 3, whether Section 3 poses a non-justiciable political question. After concluding that these threshold issues do not prevent us from reaching the merits, we consider whether Section 3 applies to the president. Concluding that it does, we address the admissibility of the J6 report before reviewing and ultimately upholding the district court's findings of fact and conclusions. Lastly, we consider and reject President Trump's argument that speech on January 6th was protected by the First Amendment. It's like how they swung and missed this many times is just astonishing. It's really astonishing. So here we go. Okay, let's get to it. The end of the Civil War brought what was one author's term a second founding of the United States. Reconstruction ushered in the 14th Amendment, which includes Section 3, which is a provision that says what to do with individuals who held positions of political power before the war and then fought on the side of the Confederacy and then sought to return to those positions. So that's how we got to this Section 3 of the 14th Amendment. Section 3 provides, and we read through this, you can't become a senator or representative if you held office, have previously taken an oath as a member of office or as an officer of the United States, etc., etc. In interpreting a constitutional provision, our goal is to prevent the evasion of the provision's legitimate operation and to effectuate the drafter's intent. Isn't this great? Here we go. We're going to sit here being the first ones in American history to explain away what this federal amendment, this amendment in the United States Constitution, we're gonna jump into the breach and tell you what this amendment means. Because we're just the state to do that. To do so, we begin with Section 3's plain language, giving its terms their ordinary popular meanings. and we may consult dictionary definitions that we like. And if the language is clear and unambiguous, then we enforce it as written, and we need not turn it to other tools of construction. But if the provision's language is reasonably susceptible or multiple interpretations, then it's ambiguous, and we may consider the textual, structural, and historical evidence put forward by the parties. Okay. And we will continue to construe the provision in light of the objectives sought to be achieved and the mischief to be avoided. These principles of constitutional interpretation apply to all sections of opinion in which we address the meaning of any constitutional provision. And here we are sitting as a Supreme Court of Colorado, and this is how we think we're supposed to deal with federal law, federal constitutions. Elector's claim is grounded in sections 1, 4, 1204. So what do you got here? A state court has authority to adjudicate a challenge to the president's candidate qualifications under the election code. So what's the election code? What's our election code that's giving us all this power to do this? So section 1.4.1204 and 1.1-113 of the election code. They argue there would be a breach of duty or other wrongful act on the election code of the secretary to place Trump on the presidential primary ballot because he is not a qualified candidate based on section 3's disqualification. Okay. The electors therefore seek an order pursuant to section 113, directing the secretary not to list President Trump on the presidential primary ballot for the election to be held on March 5th, 2024. Trump and the GOP contend that Colorado court lacks jurisdiction over the elector's claim. Electors cannot state a proper section 113 claim, in part because the elector's claim is a constitutional claim that cannot be raised in section 113 action under this court's decision in Frazier v. Williams. The GOP also says the secretary doesn't have authority to interfere with the political party's decision-making process or to interfere with the party's First Amendment right of association to select its own candidates. Meaning, if we want to put up here a gorilla and make that gorilla a candidate in our primary, that's our decision. That's not up to the Secretary of State. It's a political issue. We're deciding who we want to list for our party. So if we put up Pepe the dog, or or anything, we put up a statue of Gerald Ford. That's our call. Lastly, President Trump argues that the expedited procedures under Section 113 are insufficient to evaluate the elector's claim, which it obviously is. Before considering each of these arguments in turn, we first explain the standard review for statutory interpretation, then provide an overview of the election code provisions. So here we go. Precisely. See, this is how Chris Christie's hoping to get it. Obviously, he's one of those larger gorillas, but I was very careful when I said Pepe the dog. Turning to interveners. Oh, you're too kind. Thank you, Worcestershire. You're way too kind. I had to start early tonight. We had to start early. There's a lot of ground to cover. All right. So the intervener's contentions, we first conclude the district court had jurisdiction to adjudicate the elector's claim under Section 113, but recognize the ability to exercise jurisdiction here does not mean that they can state a proper claim. So jurisdiction is the authority to make a decision. That doesn't mean... So the court might have jurisdiction, but that doesn't mean that your claim has validity. Okay. I know. And who says it's up to the Secretary of State to say otherwise? Like, why is that even the Secretary of State's call? And by the way, even though this was, I don't like people typing in all caps because I don't think it's like productive. I do think this likely will help Trump. I think this is, you want to martyr him. Go ahead. Go ahead. Martyr him. Do it. Tell the entire country that he's too scary to try running against him. Do it. Do it. I don't think this is bad for Trump in the long run. I don't think this is bad for Trump at all. I mean, it's potentially amazing for Trump. But the left is invariably its own worst enemy. Well, first, its own worst enemy are the people that the left are trying to help. The first enemy, the worst enemy they are the people that are purporting to help. We explore whether states have the constitutional power to assess presidential qualifications. So first, we have to ask, do states have that right? We conclude that they do, provided legislatures have established such authority by statute. So if the legislature says we're allowed to do it, then they can decide who's going to be running in elections. Analyzing our election code, we say that the General gave Colorado courts authority to assess presidential qualifications, and therefore that the electors have stated a proper claim under sections 1.4.12.4 and 1.1.13. Amen. Hear, hear. God bless you. Great to see you, Mr. Shaw. We next address interveners' related arguments and conclude that limiting the presidential primary ballots constitutionally qualified candidates does not interfere with the GOP's associational rights under the First Amendment. Okay. They're going to come to that conclusion, I guess, eventually. And finally, we conclude that Section 113 does provide sufficient due process for evaluating whether a candidate satisfies constitutional qualifications for the office he or she seeks. We review the district court's interpretation of relevant statutes de novo. So de novo is a Latin term meaning anew, afresh, for the first time, as opposed to when they give deference to the lower court, and they're looking for error for that they'll only overturn it if there's judicial error. So de novo means we're going to pretend that nobody's decided this before and come to our own conclusions on this. So we're not going to rely at all on what the lower court put in when they wrote. Because sometimes a court is bound to look at something in a light given to it, in the light of the findings of the district court. In other areas, they review it afresh and don't look at that. In doing so, our primary objective is to effectuate the intent of the General Assembly by looking to the plain meaning of the language used, considered within the context of the statute as a whole. An undefined term, we construe a statutory term in accordance with its ordinary or natural meaning. If the language is clear, we apply it as written. If, however, the language is reasonably susceptible of multiple interpretations, we may turn to other tools of construction to guide our interpretation. This sentence here, I plan on spending a great deal of time, because the conclusions that they reach invariably show a flaw in the way that this court has conducted itself. The court, I don't mean simply this court, I mean this court in the context of what happened at the trial courts. And this is something that I don't think other attorneys are going to realize, because few of them follow the case. We're going to come to this relatively soon. Now, if they're laying as they talk about their application of this issue, because this court, the trial court, not the Supreme Court, the trial court did something very unusual, which is that they brought in expert witnesses to walk them through the language and origin of various terms used in Section 3 of the 14th Amendment. This is a strange thing. This is not something you see every day. Because normally, that's not a question of fact. That's a question of law. You don't have evidences, you don't have witnesses come in and testify about law. They're testifying about facts. So when an expert witness is coming in and testifying about what words mean, the only way that that could possibly be proper is if that is testimony about a fact, not what the legal termination of those words, definition of those words. So the judge was using that testimony to come to her conclusions in understanding Section 3 of the 14th Amendment, the factual findings that she's making as to this one's accurate and that one's inaccurate, because there was a battle of experts as to what the words actually mean. Well, I'll come further. We'll address this further when we come to the application of this. These may include consideration of the purposes of statute or circumstances under which the statute was enacted, the legislative history, consequences of particular construction. We also avoid illogical or absurd results. Good for you. Okay, that's very, very insightful. Okay. Before presidential primaries under the election code. Before addressing the merits, we provide a brief overview of the election code's provisions relating to the primaries. The Colorado Constitution commands the General Assembly to pass laws to secure the purity of elections and guard against abuses of the elective franchise. So the Secretary's duties on the election mean that they have to supervise the conduct of the primary. They can't just go and do their own thing. So we understand that the General Assembly has the Secretary of State and puts the Secretary of State in a supervisory role. Part 12 of Article 4 of the Election Code governs presidential primary elections. It explains that it is the intent of the people of the state of Colorado that the provisions of Part 12 conform to the requirements of federal law and national political party rules governing presidential and primary elections. So here is where they are saying that this reference indicates the legislature. What does our Colorado legislature think the General Assembly is supposed to do? Are they supposed to interfere with a political party's primaries or not? And we're saying that it is their role, it is their duty to actually oversee the primaries, including requirements governing presidential primary elections. As such, it is instructive when interpreting other provisions of Part 12. The election code limits participation in the primary to qualified candidates. Each political party that has a qualified candidate is entitled to participate in the Colorado presidential primary election. As a practical matter, the mechanism through which a presidential primary hopeful attests that he or she is a qualified candidate is the statement of intent, through which a presidential primary hopeful. So how does someone who hopes to be a political party's candidate express that they are a qualified candidate? They issue what's called a statement of intent. The Secretary's statement of intent form for a major party presidential primary candidate requires the candidate to affirm via checkboxes that he or she meets the qualifications set forth in Article 2 of the Constitution of the Office of President. Specifically, that the candidate is at least 35 years old, a resident of the United States for at least 14 years, and natural-born citizen. Okay. The form further requires candidates to sign an affirmation that states, I intend to run for office and solemnly affirm that I will meet all qualifications for the president office prescribed by law. Okay. They're going to fixate here on these words that they italicize. I solemnly affirm that I will meet all qualifications for office prescribed by law. No party has challenged the Secretary's authority to require candidates to provide this information on the statement of intent form. Okay, so General Assembly has allowed the Secretary of State to issue this form and have candidates sign off on this. Section 1-4 requires secretaries to certify the names and party affiliations of candidates to be placed on the presidential primary election ballots at least 60 days before the primary. And Section 1-4-12-4 further states the only candidates whose names shall be placed on the ballots for the election shall be those candidates who are seeking nomination of a political party as a bona fide candidate for the President of the United States pursuant to political party rules and are affiliated with a major political party that received at least 20% of the votes cast by eligible electors in Colorado and have submitted to the Secretary not later than 85 days before the day of the primary a notarized candidate statement of intent. Section 1-4 allows for challenge to the listing of any candidate on presidential primary. So, in order, if you want to get on the ballot, you have to jump through these hoops. And these hoops include that you're basically saying that you're eligible under Article 2 of the Constitution, which is 3 primary requirements that most of us are familiar with. That if you want to be a president, you have to be 35 years old, natural-born citizen, and resident of this country for the last 14 years. There's also this oath that you are going to fulfill all other requirements, which, by the way, even if he had engaged in insurrection, he could be pardoned of that. And so he can sign that oath, which is a little strange that they're just sort of dismissing that. Any such challenge must be brought no later than 5 days after the filing deadline for candidates and provide notice of the alleged impropriety that gives rise to the complaint. District court must hold a hearing no later than 5 days after the challenge is filed to assess the validity of all alleged improprieties. Statute does not limit the length of or content of the hearing, and however requires district courts to issue findings of fact and conclusions of law no later than 48 hours after the hearing concludes. So this is a fast, it's got to be a zip process. That's under our statutes. Party filing the challenge is the burden to sustain the challenge by preponderance of evidence. Hello, fellow Donald Trump MAGA supporters. Please remind us how nonviolence actually means violence and when that nonviolence will be taking place. Well, when I say don't get violent, I mean it sincerely. Much as I'm positive that when Trump said it, he meant it sincerely too. Now, expert witness Professor Simi said that when Trump says to do something bad, or implies to do something bad, he definitely means to be something bad. And when he says, don't do something bad, that's his wink, wink saying, I mean the opposite of what I'm saying. He knows this because he interviewed, according to his testimony, 0 people who were arrested for going into the Capitol on January 6th. But he has a perfect understanding as to what went through their minds. And he was clearly sufficiently compelling that the district court judge says, oh, wow, he engaged in insurrection here. Challenges under Section 1-412 forms were brought through a special statutory proceeding. But no one cares about this part of it, other than just checking off that things are done procedurally properly in Colorado. And provide that any challenge to listing a candidate on the presidential primary ballot must be made in writing and filed with district court in accordance with Section 113. Any order of the district court has to be reviewed by the Supreme Court. So we ultimately had to deal with this because it's got to come to the Supreme Court of Colorado. Section 113 has deep roots in Colorado election law, and no one cares much about that. And we had these established procedures for controversies going for any candidate for a long time. The current version of 113 establishes that the exclusive method for adjudication of controversies arising from breach or neglect duty or other wrongful act occurs prior to the day of election. It says any controversy arises between an official charged with the duty of function, Secretary of State, under this code, and any candidate or any officers or representative of the political party or any persons who made nominations or any eligible elector files a verified petition in district court that under this code has committed, is about to commit a breach or neglect of duty or other wrongful act. So there's an allegation that Secretary of State is going to engage, is going to commit a wrongful act by putting Trump on the primary ballot. I do want to point something out to you, by the way. I want to point something out to you. A lot of you might be thinking to yourselves, I'm just going to pause on this, just correct you on one thing. Those of you who think that, you know what, this is going to create such pro-Trump sentiment that there'll be tens of millions who are going to write him in any state that he's kept out. You may be accurate in that. However, if he's officially ineligible, even if he's written in and gets majority of votes, they won't count it. That's just the way the law works. So that end around saying, we don't care what the courts say, we're going to write him in anyway, that ain't going to work. That will not be effective. Will not be legally effective. Might do other things, but it's not going to be legally effective. Just want to make that clear. I looked into this. At least in Colorado. I can't tell you other states. Section 113 proceedings also provide for expedited, albeit discretionary, appellate review. Either party may seek review from this court within 3 days after district court proceedings conclude. The district court's decision is, and if we decline jurisdiction, this district court's decision is final. All right. No one really cares much about the procedural things, but they do have to get this out of the way in order to show that they're being thorough and, following their own rules. And they're trying to establish whatever level of legitimacy to this decision that they can, seeing as how they spend so much time going on an expedition into areas of law that they should not have ever ventured into, in my personal opinion. Although Colorado's expedited statutory procedure for litigating election disputes may be unfamiliar nationally, our courts, particularly the Denver District Court, proper venue as Secretary as the name responded, are accustomed to Section 113 litigation. Just to point out to you, by the way, when they say our courts are accustomed to this type of litigation, the particular judge who was assigned to this case and refused to recuse herself from this case, despite the fact that she gave money, her own personal funds, to an organization that was protesting the GOP's placement of Trump on the Colorado presidential primary ballot. Yes, she did. $100 that she donated to that organization and said, I don't remember doing that. And I don't really care about that. So no, I'm not. It's not something I have to recuse myself for, which a lot of people find to be fairly outrageous. This as well-established judge was appointed to sit, is a veteran of the Colorado District Court. She's been sitting in her office as a judge since January of this year. So she has seen it all. She understands litigation in this area because she's been sitting since January of 2023. She's been a judge that long. Not at all tainted, not at all biased, not at all anti-Trump in reaching any of these conclusions. Not at all. Totally proper in not recusing herself. And you should know, you might, on a national level, because we understand people are reading this on a national level, just understand this. We here in Denver, we here in Colorado, we have a great deal of history of dealing with election issues. So we know what we're doing here. Such cases arise during virtually every election cycle. This court has exercised jurisdiction many times to review these disputes. So we know this is old hat for us. Moreover, it's not uncommon for Section 113 cases to require courts to take evidence to grapple with complex legal issues. And yet somehow this is a matter of first impression. Go figure. I'm skipping past the little parentheses because no one cares about anything here. But the point that the Colorado Supreme Court wants you, the national public, to understand is that the original 1894 provision contemplated that we are allowed to take evidence where the issues require it. So us having a hearing on this sort of thing, you might think that's weird because that's not what happened in Minnesota. It's not what happened in Michigan. It's not what happened anywhere. It's just how we do stuff. That's how we do our business here in Colorado, and that's how our legislature has set up for us since 1894. We spent 130 years doing this type of lunatic type of work. The district court had jurisdiction to adjudicate the elector's claim under the election code. President Trump argues that the district court lacked jurisdiction over the elector's section 113 because the secretary has no duty on the election code to investigate a candidate's qualifications. So, first argument, Trump and his attorney, by the way, Scott Gessler, was amazing attorney. He did really wonderful work, and he will be phenomenal. I can't wait to see him argue in front of the Supreme Court because he really did amazing work. Amazing work. So Trump's first argument is that you have no duty on the election code to investigate a candidate's qualifications. It's not to you. If he's qualified, if he's human, don't matter. District court has jurisdiction pursuant to section 113 when an eligible elector files a verified petition in a district court competent jurisdiction alleging that a person charged with a duty under the election code has about to commit a breach of duty. This is a breach of duty. So in order for it to be a breach of duty, there has to be a duty for the Secretary of State to investigate the legitimacy. So this election code that you're trying to come in here, this is what Trump's argument is. You're saying that we're coming under this section of the election code because the Secretary of State is about to breach their duty in allowing someone to come in here. Does the Secretary of State have a duty to investigate? Even if they're allowed to investigate, do they have a duty to investigate the qualifications of potential candidates? Is their job? They're obligated to do that? The district court plainly had jurisdiction under section 103 to hear the electors' claim. First, the electors are eligible electors within the meaning of election code because as Republican and unaffiliated voters, they are persons who meet the specific requirements for voting in a specific election. So apparently these jackasses, who the petitioners, are able to vote in Colorado's Republican primary, which that should be a terrifying thing to you. Namely, the Republican presidential. And secondly, the electors timely filed a verified petition under section 103 and 1204 in the proper district court. So they got subject matter jurisdiction. And thirdly, the petition was filed against secretary, an election official charged with some duties, whether this is one of them is a different question. And fourth, the petition alleged that the secretary was about to commit a breach of duty or other wrongful act by placing Trump on the primary ballot. Though it does not affect the district court's jurisdiction, President Trump's assertion the secretary does not have a duty on the election code to determine a candidate's constitutional qualification raised the question of whether electors presented a proper claim. So, if you're saying that the Secretary of State is about to breach a duty, that implies that the Secretary of State has a duty. But is that actually the Secretary of State's duty to investigate into someone's qualifications? To answer that question, we must first determine whether generally states have the authority to determine presidential qualifications. Okay. So, states have the authority to assess presidential candidates' qualifications. Common sense, as well as constitutional law, compels the conclusion that governments must play an active role in structuring elections. Okay. That I can go along with. That makes sense. Constitution delegates the states the authority to prescribe the times, places, and manner of holding congressional elections. And states exercise these powers through comprehensive and sometimes complex election codes. So we have a right to assess. States have a right to assess the candidate's qualifications. Is that the election stage or the primary stage? These powers are uncontroversial and well explored in U.S. Supreme Court case law. But does U.S. Constitution authorize states to assess constitutional qualifications of presidential candidates? So just because we're allowed to assess whether or not someone is qualified to serve, let's say, as governor of Colorado, do we have the right to figure out who's going to be the president of the United States? We say that the Constitution gives us that power. The U.S. Constitution gives us that power. That's a bit of a stretch. Okay. Under Article 2, Section 1, each state is authorized to appoint presidential electors in such manner as the legislature thereof may direct. So long as the state's exercise of appointment power does not run afoul of another constitutional constraint, that power is plenary. Plenary means we got carte blanche. You do whatever the hell you want. As long as you're not violating the U.S. Constitution, you have carte blanche. You have the entire ambit of anything like a king. Like it's your sovereign domain. You can decide how you want to do it, as long as you don't run afoul of that. Every state legislature has that power to decide how we're going to determine who our electors are, as long as we don't run afoul of the U.S. Constitution. Okay. The voters no longer choose between slates of electors on election day. Instead, they choose for presidential candidates who serve as proxies for the pledge electors. Accordingly, states exercise their plenary appointment power not only to regulate the electors themselves, but also to regulate candidate access to presidential ballots. Since we're not choosing between slates of electors on election day, we're voting for candidates. So now all of a sudden we used to have a whole power with respect to electors. But now, since people are voting directly for candidates, we now have the right to look at a candidate and which candidates are accessing presidential ballots. That's not a crazy logical leap. That's not an unreasonable. I think that's a reasonable logical jump. Absent a separate constitutional constraint, then, states may exercise their plenary appointment power to limit presidential ballot access to those candidates who are constitutionally qualified to hold office of president. If that's what the legislature wrote. Yeah. And nothing in the U.S. Constitution expressly precludes states from limiting access to presidential ballot. Okay. So we have the power to do that. No part in this case has challenged the Secretary's authority to require presidential primary candidates to confirm on the required Statement 10 he or she meets Article 2 requirements of age, residency, and citizenship. So those three basic requirements, no one's questioned that the Secretary of State has a right to investigate there and to further attest that he or she meets all qualifications for the office prescribed by law. Moreover, several courts have expressly upheld states' ability to exclude constitutionally ineligible candidates from their presidential ballots. So we're not alone in that. As then Judge Gorsuch recognized in Hassan, it is a state's legitimate interest in protecting the integrity and practical functioning of its political process that permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. So, since that's what Judge Gorsuch wrote in Hassan, that it is within a state's legitimate interest that they want to make sure they're only having legitimate candidates run. So the question then becomes whether Colorado has exercised this power through the election code. Did they actually direct this? We conclude that it has. Surprise, surprise. Section 1204 is Colorado's vehicle for advancing these state interests. When eligible electors challenge the Secretary's listing on a presidential primary ballot of a candidate who is not constitutionally qualified to assume office, as exercised through a proceeding under Section 103, offers an exclusive remedy under the election code. The electors have stated, but does that mean it's a duty? Just because they're allowed to look does not mean it's a duty for them to look. Maybe that's part of this next Section 5. Trump argues that electors' claim could not be properly litigated in Section 113 because the Secretary has no duty under the election code to investigate candidates' qualifications. There we go. This is what I said. Is there a duty? Unless there's an obligation on the Secretary of State, in that case, there's no duty to be breached. Because this court's precedent bars litigation of constitutional claims in Section 113 action, although we agree that the Secretary has no duty to independently investigate the qualifications of a presidential primary candidate, we conclude that the electors may nevertheless challenge a candidate's qualifications, and that the elector's claim here is not a constitutional claim precluded by decisions in Fraser and Kuhn. What? If the Secretary has no duty, then how the hell can they be breaching a duty? My God. My God. How twisted are you? How twisted? How twisted? Although we agree the Secretary has no duty to independently investigate the qualifications, then how can there be a claim that the Secretary is breaching her duty? How can that possibly be? How can that be? You can't breach a duty of care if there is no duty of care. Most of these have been stated. Most of them have been stated. The elector's claim here is not a constitutional claim included by decisions of Fraser and Kuhn. In presidential primary elections, Secretary's duty is to certify the names and party affiliations of the candidates to be placed on any presidential primary ballots. Conditions that must be satisfied before she can exercise this duty are limited to timely receiving confirmation that his prospective parents' candidate is a bona fide candidate under party rules, and a notarized statement of intent, and records of filing a petition signed by 5,000 eligible electors. When a candidate does not submit or cannot comply with required attestations, the Secretary can list the candidate under the ballot. So if you can't fulfill requirements, that's where Hassan comes in. You can't meet. If you don't meet the state requirements, you can't get on. So Judge Gorsuch said, okay. But if the contents of a signed or notarized statement are intent appear facially complete, everything looks good, the Secretary has no duty to further investigate the accuracy or validity of the information the prospective candidate has supplied. So let's say someone comes along and says, I'm 42 years old and I was born in this country and I've been living in the same house for the last 40 years and I'm running for president. Is there a duty for the Secretary of State to look into that? Let's say, what the hell are you talking about? You're Elon Musk. You're born in South Africa. That ain't true. To that extent, we agree with President Trump. The Secretary has no duty to determine beyond what is apparent on the face of the required documents whether a presidential candidate is qualified. Okay. And yet there's still more to be written after this. So let's see why. Because that would seem to be that this entire case should go away. The fact that the Secretary has complied with her Section 1204 duties does not, however, foreclose a challenge under 1204. As discussed above, 1204 permits any challenge to the listing of any candidate on the presidential primary election ballot under Section 113 as a procedural vehicle. 113 in turn creates a cause of action for electors alleging a breach of duty or other wrongful act under the code. So it's not a breach of duty. There's a different wrongful act by Jenna Griswold, Secretary of State, if she puts Trump on there. Okay. Section 113 requires district court, not the election official, to adjudicate the eligible elector's challenge to a candidate's eligibility. So any candidate, can I come in there under Colorado law and challenge Biden's legitimacy under the 25th Amendment? Say he's not competent. You're going to challenge his legitimacy. We need to have a competency hearing on President Biden. I don't know why anyone hasn't filed that yet in Colorado. This is what Colorado law says. That's going to trigger it? Is that going to trigger it? I don't know. She's trying to explain that. I'm sure that 2 of the people who sign off on this at least are women. Positive. Positive. I haven't seen the names yet, but I'm positive that they are. Section 103 requires district court, not the election official, to adjudicate the eligible electors' challenge for candidates' eligibility. This is so bizarre. It's such a weird way of reading your own statute. Because this literally means that anyone can say that, hey, there's a wrongful act in the Secretary of State and putting Biden up there because he's not competent. And that's an invalidity under 25th Amendment. I don't understand that. It's so stupid. As we explained, that's not a logical read of your own statutes. As we've explained, the Secretary has complied with her limited duty to accept Trump's properly completed paperwork, but the electors have alleged an impending wrongful act which is more expansive than a breach or neglect of duty. More expansive, meaning we can read it any way we want. Indeed, 113 clearly comprehends challenges to a broad range of wrongful acts committed by officials charged with duties under the code. It's a catch-all we can use whenever we want, and we want to use it now. We conclude that certifying an unqualified candidate to the presidential primary ballot constitutes a wrongful act that runs afoul of 1203. We're not at all twisted, at all, or biased. It undermines the purposes of the election code. Nothing in 1204 limits challenges under the provision to those based on the breach of the Secretary's duties of 1204. At this point, this is, you don't even need to go any further to say we're bending over every way possible to try and figure out how we can keep off the ballot, because this makes no sense. You're basically saying we can interpret anything we want to be a wrongful act because it's much more expansive than breach of duty, any wrongful act. And this is what we like, so we're gonna go for it. It's like such an overreach of judicial power. It's unbelievable. Section 1203 clearly limits participation in the presidential primary to the political parties fielding qualified candidates. Although 1203 does not define qualified, nearby provisions require writing candidates that qualified refers to a candidate's qualifications for office. So we're going to try and twist it that way. Ed, my buddy, Biden isn't qualified to hold office because he's guilty of bribery, even though he hasn't been held guilty yet. They're doing that to Trump as to... I agree with you on that also. He's guilty of treason. I think he's committed treason. We should have to defend on that. Force him to defend on that. We should have a whole hearing on that. Have 50 states all deciding that. This is why, look, I think it is more likely, before we go any further, because I know that, look, I got ways to go here. Before I go any further, I just want to tell you this. My expectations for this case is that it will be granted certiorari by the Supreme Court. And the Supreme Court is going to say, go jump in a lake. We're not having 50 different states deciding on something. That doesn't make any sense. Some states say yes, some states say no. I am very confident that we will see at least 6 justices who will find this to be retarded and stupid and a ridiculous application of their own law and a very poor misread of the United States Constitution. And I think it's more likely it will be 9-0 in favor of Trump than it being 5-4 against Trump. Because there's a lot of reasons for the entire Supreme Court to say that this is stupid. First and foremost, Supreme Court is all about federal power. They love having more federal power. Giving states the right to decide who can run for president of the United States sounds like you're ceding way too much power to states. So That's why I think those corporate bigwigs, I think that they're really not going to like the idea that every state can just decide who we putting on our ballot, who we not putting on our ballots. Second of all, like I said, there literally were 8 decisions that had to go against it. Like 8 different things that you have to decide every single one of them against. And I think that there might be some arm twisting, which will happen from Chief Justice Roberts, where he's going to be like, he's going to say to those other 3 justices that you know that this is crap, you know this is stupid, and you know that this is going to be divisive to our country if you split us 6-3. And you know he's going to win. You know that we're putting him in here. And if you 3 justices decide to hang out there saying, no, he's the third under Section 3 of the 14th Amendment, and try twisting that amendment into applying to him or whatever, that's why you think that he should be held off of the election. If you try going down that road, you are going to tear this country in 2. And Chief Justice Roberts, who sees this coming, he probably should have had this conversation tonight with Sotomayor, Kagan, KBJ, and say, you are going to F this country up unless you side with us on this. Because, and here are all the reasons as to why that this Supreme Court of Colorado is out of their blooming minds. List off all the different flaws and problems and say, this is a matter of national interest. We need you to stand with us, because otherwise this is going to create such a deep political divide. And the left is going to be like, oh, it's the Republicans who are standing against. The way you don't have that fight is if those three yokels there on the left side, they're like, no, you can't do this. We're not doing this. We're not keeping them off the ballot. That's how you do it. That's how you do it. Colorado Republican Party just posted, we will withdraw from the primary as a party and convert to a pure caucus system if this is allowed to stand. Ooh. Wow. I told you, this is the most significant state court decision to my mind. I challenge you, I defy you to come up with any state court decision on any level of state court ever in American history that was more significant than tonight's ruling from the Colorado Supreme Court. It's crazy. I have not looked in Rumble in like a year and a day. I've been very tired, and I apologize for that. Let me peek in here. I've been very, very tired. I'm working hard. I apologize to you guys. I got 8 of you over here in locals. Okay. Thank you for sharing that with me, Mary Cedar Rose. Let's get back to work. So trying to figure out what a qualified candidate is. And qualified candidate, it refers to candidates' qualifications for office. As with bona fide major party candidates, that writing candidates must file a notarized candidate statement of intent. Under the election code, such statements for writing candidates must indicate candidate desires the office and is qualified to assume its duties if elected. No, actually it says will be qualified. That's different from is qualified. Those are 2 different things, and that's relevant here. Where do they cite this statute? I'm almost positive it says will be qualified. They mentioned it earlier. Can I find it in here? Control. Maybe not. Look real quick. That makes no sense. Maybe it's not qualified. Maybe it's qualify. Yeah. Definitely saw something. Maybe it's an eligibility? Is it eligible? All right. Let's go back. Oh, for the love of God. So, as we explained, the secretary has complied with the limited duty to accept President Trump's paperwork. Electors have alleged an impending wrongful act, clearly comprehends challenges a broad range of wrongful acts, and that's inconsistent with the election code. We conclude that certifying an unqualified candidate is a wrongful act, and we can do whatever we want once we say it's a wrongful act. So, once we're calling it under that massive umbrella. And reading the election code as a whole, we conclude that qualified in 1203 must mean at a minimum that's qualified under the U.S. Constitution to assume duties of office of president. Why would it not be Article 2 of the Constitution as a minimum? See, that's a minimum. How do you have a minimum of something beyond Article 2? It has to. As Section 1203 supplies the only textual basis election code for the Secretary's authority to require a presidential primary candidate to attest to his or her qualifications. See, here's how you know that this is such a ridiculous reading. The reason it's a ridiculous reading, if you just think this through for a second, is because there's a lot of different bases as to why someone might be disqualified. One of them would be if they're a mental vegetable. Is that one of the disqualification characteristics? Like, at which things, or running for a third term? How do you know which of these are self-effectuating and which ones are not? Are they supposed to start searching in every person here as to, like, let's say it wasn't something as public as Donald Trump. Let's say it was someone who basically engaged in some sort of rebellion or something like that, some sort of insurrection that never caught national attention and did that in Rhode Island. Now they're running in Denver. It's so backward. Meaning they did that as an officer of the peace. So they had sworn an oath under the Constitution to uphold the Constitution, and now they're running for senator. It's up to the Secretary of State to start looking into that. That's as a minimum. When you say we qualify, must mean at minimum that they qualify under the Constitution, assuming the office of president. What would be maximum? What the heck would be maximum? How do you put the words at minimum here? This is what makes you a joke when you write at minimum. No, it's at maximum because you're by this yardstick. There's so many different ineligibilities someone can have. It has to. Supplies the only textual basis of election code for the Secretary's authority to require a presidential primary candidate to attest to his or her qualifications for office of intent. Moreover, to be qualified not to encompass federal constitutional qualifications would undermine the purpose of the election code to secure the purity of elections. How about just sticking to Article 2, which is natural born citizen, over 35 years of age, living here for 14 years. We therefore reject such an interpretation as contrary to the purpose of the election code. Okay. Instead, we conclude that under the election code, qualified candidates for presidential primary are those who, at minimum, qualified to hold office under the provisions of the U.S. Constitution. There's a lot of provisions of the U.S. Constitution. I don't think you're looking into the cognitive abilities of Biden and making assessments as to whether or not he's able to withstand a challenge on the 25th Amendment. We recognize the Supreme Court has twice declined to address whether Section 3, which disqualifies an oath-breaking insurrections from holding office, amounts to disqualification from office. We don't care. To hell with the Supreme Court. That's pretty funny. Where were those times? Section 3 and similar disqualification provisions of the federal constitution declined to address whether such provisions constitute qualifications for office because both sides agree the candidate was not eligible under Section 3 or any other similar provision. And then 1995, seeing no need to resolve the same question regarding Section 3 in a case concerning the proprietary of additional qualifications for office. But lower courts, when presented squarely with the question, have all but concluded that Section 3 is a functional equivalent of a qualification for office. Really? That's interesting. Green versus Raffensperger. Section 3 is an existing constitutional disqualification adopted in 1868, similar to but distinct from the Article 1, Section 2 requirements that Congress candidates be at least 25 years of age. Okay. We perceive no logical distinction between disqualification from office and a qualification to assume office, at least for the purposes of Section 113 claim here. Either way, it'd be a wrongful act for the Secretary to list a candidate on the presidential primary ballot who is not qualified to assume the duties of his office. Here's the fly in the ointment, and this is something I need to pause. I want to close this for a moment here, so I have your attention. Here's the fly in the ointment. The reason that you would say that the Secretary of State has a duty to keep someone off the ballot who's ineligible is because now, well, what happens if the Secretary of State fails to do that? Let's say a 30-year-old runs for president, and they say, we're going to let this person be our electors, going to send our electors in to support this individual who's 30 years old. There's absolutely zero chance that that person will ever be able to assume the office. We know that. So you're basically standing up for Coloradans' collective ability, to send forward someone who can actually serve in the role. That's why you would have provisions in your elections code that empower the Secretary of State to keep someone off, so that the will of Coloradans is not thwarted by them voting for someone who could never possibly ascend to that office. But when Colorado alone is making a determination that Trump is ineligible to serve, and no other states have made that determination, does that mean that he would be incapable of ascending to that role? Of course not. Who the hell's keeping him out? No one's keeping him out. Hence, it makes zero sense to say that the Secretary of State is protecting Coloradans, standing up for Coloradoans to make sure that their voice is heard. Because what's the fear? The fear is we're going to send that person off there, and then they're going to show up there, and all the locals are going to be like, what the hell are you doing here? You're ineligible to serve. We send in a senator who's clearly ineligible to serve. They're going to show up in D.C. and be thrown out. I mean, like, you can't serve here. So it makes sense, Secretary of State, to say, yeah, we're not going to go through that process. Otherwise now Coloradoans are not going to have their representative there because they sent someone who's ineligible. But if you alone, you're a state that's saying he's ineligible, but the federal government has not issued any ruling, any finding that he's ineligible. So is he not going to be, and he were elected by Coloradoans, would he not be able to fulfill that role? Of course he would. So who the hell is the Secretary of State protecting? Who are you protecting? It's not a shield to protect Coloradoans. This is a sword. That's what this That's what this Colorado Supreme Court is doing. They're using what's designed as a shield and saying we have to shield Coloradoans, and taking that shield and hacking and wicking and whipping and whipping and whipping and using all sorts of alchemy to basically change the contents of this. And all of a sudden, we got a big freaking lightsaber to knock Trump out of here. It's ridiculous. There's no possible logic behind it. But so be their will. Hey, Pam, I am new member of the following. Welcome to the following. The following, all members of the following, anyone who becomes a member of this channel is a member of the following. Following is a reference to followers, not followers of me, okay? Because this is not a very culty type of cult at all, and I'm not the leader of this non-culty at all like cult. So there's no Kool-Aid, no spaceships, no self-harm, no harming others, no engaging in any sort of jousting. Despite all the rumors to the contrary, there's no goat herding, no tracksuits, minor amounts of physical labor. Primarily, this is all about community, union, personal growth, and I am not the leader of the following. I'm a follower, just like you. So don't make that mistake. A lot of people make that mistake. I'm not surprised by this ruling. Democrats are not allowing Democratic primary in some states, even though there are 3 Democrats running. Interesting. B-Man. Okay, it took his name off the primary ballot, but can they still write it in? So I addressed this earlier, and the answer is no. If this is not overturned, any Coloradoans who write his name in, I don't know how many Coloradoans there are, but if there are 20 million votes cast in Colorado that by write-in for Trump and 6 votes for a Democrat wins. That's just the way it is. And we know that we'll find at least 6 dead people. So, yeah. Good question. I'm sure I'll get that question again, but I looked this up. That's my understanding of Colorado law. Colorado admits that the U.S. Constitution is a source of presidential candidate qualifications. It follows that the U.S. Constitution is a source of disqualification. That determination is rightly Congress to make, not Colorado. Ed, you're preaching the choir, my friend. You are preaching the choir, but it's a great point. It's a great point. It is. That's what I said. They will be voided. And yeah, it is technically right-in. Unless it's a whole Kamala Harris thing saying, don't come. Don't come. All right. Moreover, because Section 3 is part of the text of the Constitution, assessing candidates' compliance with it for purposes of determining eligibility for office does not improperly add qualifications that those that appear in the Constitution. Well, you know what? It's not in the articles. So that makes it kind of new. Where's your whole concern about the 25th Amendment? Merely renders list of constitutional qualifications more complete. Oh, this is more complete. What about the fact that he could be pardoned? For all you know, if he ever were found guilty of engaging in insurrection, he could be pardoned. So he's not necessarily ineligible. At what point is he ineligible? He's not been determined ineligible by the federal government. Nor are we persuaded by Trump's assertion that Section 3 does not bar him from running for being elected to office, because Section 3 bars individuals only from holding office. Hassan specifically rejected any such distinction. I agree with that. There, the candidate argued that even if article properly holds him ineligible to assume the office of president, Colorado cannot deny him a place on the ballot. See, I agree with him on that. I think Hassan panel concludes otherwise. This I agree. This law, I think, is not one of Trump's stronger claims. In any event, the provisional election code governing presidential primary elections do not recognize such distinction, so I don't need to worry about that. While we adopt President Trump's view, were we to adopt Trump's view, Colorado cannot exclude from the ballot even candidates who plainly do not satisfy age, residency, and citizenship. Yeah, and that's a fair point. Like I said, not a strong argument. It would mean that the state would be powerless to exclude a 28-year-old or non-resident of the United States, All of a sudden, Fidel Castro is going to be on the ballot here in Colorado. That's not good. President Xi is going to appear on our ballot. Lastly, more likely President Xi. Lastly, we reject President Trump and the RP and the GOP's argument that state courts may not hear electors' claim because the court's president bars litigation of constitutional claims in Section 113 action. From Kuhn. The electors have not asserted a constitutional claim. That's a nice way to skin that baby. Fraser and Kuhn addressed whether a petitioner could shoehorn a claim challenging constitutional election code into Section 113 proceeding. In Fraser, we include that 113 is not a proper vehicle to resolve claims under 42 U.S.C. 1983 because they do not arise on the election code and because the sole... That's weird. That's federal tort claims. It does not arise under the election code and because the sole remedy available under 113 is a court order directing compliance with the election code. Similarly, in Kuhn, we held that the extent candidates sought to challenge constitutionality of a particular circulator residency requirement under the election code, the court lacked jurisdiction to address such arguments in Section 113 proceeding. Okay. Here, how electors do not challenge constitutionality of the election code. Nor do they allege a violation of the Constitution. Instead, they allege a wrongful act. And we're going to give that as broad a reading as we can possibly give it in order to make this a viable claim. Neither President Trump nor the GOP suggest that Section 113 cannot have constitutional implications because that's a losing argument. As discussed above, the elector's claim is that the secretary will commit a wrongful act under the election code if she lists candidate as the president's primary ballot who's not qualified for office. The problem is that how could you ever possibly declare him unqualified today? That's the issue. How can anyone declare him that? The other issues that you raise, one could easily be disqualified today. You cannot label someone disqualified under Section 3 of the 14th Amendment because you don't know that they'll be disqualified by the time they show up and get to Congress. While his claim requires resolving constitutional questions, it remains a challenge brought by eligible electors against election officials regarding an alleged wrongful act. All right, limiting presidential primary ballot access to constitutionally qualified candidates does not interfere with the GOP's First Amendment rights. Breck Nichols. Holy heck, almost 2 years. One of my first members of the following. My God, it is great to see you, brother. Greetings from Dallas, Texas. I just want to state for the record that I was born in Little Rock. Go Razorbacks. Here's a crazy, not to risk agitating any of y'all. Here's a crazy little known fact. My favorite college football team does not play within 500 miles of any state I've ever lived in. And even though many of you know I'm a Dallas Cowboy fan, not from Texas. But, yeah, I'll give a free membership to anyone who can be the first one to guess. I don't know. Actually, I shouldn't say that because I don't know how to gift a membership. How do I gift a membership? Can I gift a membership? Can I do that? Is such a thing possible? Is such a thing even possible on YouTube? But, yeah. I'll tell you what. I'll send first person who can guess properly, guesses in a super chat, I'll send one of these hats to. There you go. My favorite college football team. In fact, what I'll do is I'll even Give me a second here. Just so no one thinks that I'm making it up. What I'll do is I will all right, there you go. That's follow up. Let's see if anyone wants to guess. Okay. All right. Where was we? Let me get back into this. GOP argues that Section 12.4 vests it with the sole authority to determine who the Republican nominees will be on a ballot, a reflection that the GOP contends a constitutional rights to freely associate and exercise political decisions. Meaning, if now this is what the Colorado GOP is claiming. They're saying if you limit who we put on our ballot, you are limiting our freedom of association, I assume. Yeah, freely associate and exercise political decision. Taken to its logical end, the GOP's position is that it has a First Amendment right to deem any person to be a bona fide candidate pursuant to the party rules. That's a fair point. And subsequently mandate the individual's placement on the presidential ballot without regard to the candidate's age, residency, citizenship, or even whether this candidate has already served 2 terms as president. As a threshold matter, we acknowledge that the district court dismissed GOP's argument on this issue, ruling that it raised a separate constitutional claim improperly litigated in a 113 action. We agree that a claim challenging the constitutionality of the code cannot be reviewed under Section 113, but to the extent that the GOP argues in its answer brief that the Secretary lacks authority to interfere with the GOP's associational rights, we respond briefly to those concerns, and we distinguish between the right to decide the candidates with whom it affiliates and who they recognize as being bona fide. It's a fair point. The GOP's ability to place candidates on presidential primary ballot, claim that it has a right to select its own candidate is uncontroversial so far as it goes. But ultimately, they're well within their rights to choose with who they affiliate and decide who you choose bona fide, but it does not follow that you have absolute entitled to have a nominee appear on a ballot that the party's candidate. As a practical matter, any state election law governing the selection of eligibility candidates affects to some degree this right to associate that the Colorado GOP is claiming. So for all of these reasons, it's a very weak claim that we are going to reject. And I think on this matter, properly so. Section 113 proceedings provide adequate due process for litigants. Well, to answer your question here, why isn't the GOP and DNC's responsibility to ensure candidate qualification? What they're basically saying is that they have a duty to protect the rights and interests of Coloradoans. So if they were to put someone who's clearly ineligible, in that case, it's the duty of the Secretary of State to ensure that it's someone who's eligible. Lastly, Trump asserts that 113 is not a valid way to litigate complex constitutional, legal, and factual issues. He complains of unfairness inherent in expedited procedures as Section 113 demands. But Trump's argument disregards how electors' claim proceeded here. Initially, we note that the extent President Trump purports to challenge the constitutionality of 113 on the 14th Amendment's due process clause as defense to the elector's claim, he raises precisely the type of independent constitutional claim he recognizes barred by Kuhn. What? What? As discussed above, constitutional challenges provisions of the election code fall outside the scope of proper Section 113 challenge because those expedited statutory proceedings contain only one type of claim: election officials' violations of the election code, and one type of injunctive relief in order compelling substantial compliance with the election code. So what he's basically saying is that the statute as written is unconstitutional because there's no way that such a complex matter can be decided 5 days afterwards. And they're like, well, we can't worry about Constitution because that's not allowed in Section 113 issues. So this is why it's not supposed to be a state court matter, idiots. That's so circular. This is the most circular thing in the world. Furthermore, because 113 proceedings are designed to address election-related disputes, they move quickly out of necessity. So what? Just because out of necessity doesn't mean that this is not breaching his basic fundamental rights to actually, have discovery. Wow. They're so partisan. This is funny. Lawyers who practice this area are well aware of this. Looming elections trigger cascaded deadlines in both state and federal law that cannot accommodate protracted litigation schedules, so we have no other way to do it. So what if his rights are violated? We don't care. Doesn't matter. Doesn't matter. The state's interest in protecting the integrity of the election process and avoiding voter confusion. Maybe that's why this isn't meant to cover a complex issue like Section 3 of the 14th Amendment. That's what the tip-off is, guys. You try to figure out where are we supposed to weigh in and where are we not supposed to weigh in. Well, maybe if weighing in on this area is going to force a United States citizens to be deprived of their basic civil rights, that's a sign that this is not an area you're supposed to do. Maybe that's one of those signs. See, because if it was a question as to whether the person was born in the United States, that's not a complex legal issue. If it's a question as to whether they've been living here 14 years, you can probably wrap that up in 3 hours of testimony. It's a question whether or not the person is born here. You just wave a little birth certificate. Not that long. Whether or not someone engaged in insurrection after they had taken an oath, or whether that's a lot more complex. Clearly, that's a lot more complex. That should have been your clue. Well, we don't care about your civil rights. We don't need your stinking civil rights. Civil rights. We don't care about your stinking civil rights. What an embarrassment. What an embarrassment. So allows the state to expedite the process of qualification once challenged, subsequent determined. Nor does the need for expedited proceedings election disputes preclude a district court from using traditional means of case management in a Section 113 proceeding to construct a schedule that accommodates legally or factual complex issues. And clearly, there was a great deal of time here in the in the 120 hours between filing and when this motion and when this due date was actually heard. Trump contends that the expedited nature of Section 113 proceedings does not provide time for the kinds of procedures he believes the complexity of his case require. For example, filing CRCP 12 motions, testing legal sufficiency of electors' claims before the litigation proceeds, allowing for extended discovery and disclosure procedures, and a host of other basic rights that every other American citizen is entitled to. But he's never specifically articulated how district courts approach lack due process. Really? He certainly does not contend that he was prejudiced because district court moved too slowly or failed to resolve the case this week. No, it's that their timing here indicates that your entire thought that you can handle this is asinine. He made no specific offer of proof regarding other discovery he would have conducted or other evidence he would have tendered. Moreover, his arguments throughout this case have focused predominantly on questions of law and not disputed issues of material fact. In addition, District Court took many steps to address the complexities of the case. For example, the first hearing case was a status conference on September 18th, 4 days after the case was reopened after being remanded from federal court. District Court's case management approach worked. Everything here is fine. Everything's fine. After multiple interveners to participate, the District Court allowed sufficient time for extensive pre-hearing motions to which all parties vigorously engaged. So we don't really care about the fact that this was one of the most complex litigation issues imaginable that was basically thrown together, slapped together over a picnic lunch and then and then adjudicated over a 5-day trial, which most people assume would have taken a year and a half if it was actually done properly. In short, district courts admirably and swiftly discharged its duty to adjudicate this complex Section 113 action, substantially complying with statutory deadlines while demonstrating the flexibility inherent in such a proceeding to address the various issues raised by interveners. All right. For these reasons, the EC allows Colorado's courts through challenges brought under 112.4 to assess the constitutional qualifications of a candidate. Let's move along to the next section here. The disqualification provisions, Section 3, attaches without congressional action. This is now we start getting into, this is where they start hacking into the federal law, issues of federal law. Here we go. Should we have a brief intermission? Do an intermission? I'm seeing a whole bunch of notifications here. Oh, that's nice. Mario wants me to join in on his spaces. I got no time for your stinking spaces. What do you want me to do? I'm actually reading through this thing. I'm going to be one of the few people who actually read through 200 pages of this. All right. Where were we? Where was we? Where was we? That's not cool. Not cool at all. Oh, and by the way, I do need to say this. One thing I do need to say. We go to intermission. I don't know how you did that. But congratulations, Wesley. I owe you a hat. Well done. Well done indeed. You must be a longtime follower. Because I do think I told the story over as to how I became a Cornhusker fan, but it was a while ago. Good job. So I owe you a hat. What I'll suggest you do is send me your address at goodlogic@gmail.com. Name, address, and some way of verifying that I know that it's you. So I don't end up sending it to the wrong person. So, but yes, back in, I think 1980. What year was it? '84 Orange Bowl. That's why I became a Cornhusker fan. So there you go. Nebraska was playing against Miami Hurricanes. And I had great respect for Tom Osborne, deciding to go for 2 points rather than kicking a point in kicking the extra point. I was like, man, that guy's got Nebraska Honeys, because they were ranked number 1. Miami's ranked number 2. So if they had tied, presumably they would have retained the number 1 status. He's like, I'm taking this. I'm taking this. Turner Gill tried throwing 2-point conversion pass to a very young Irving Fryer, leader of the New England Patriots, which got batted away. In that game, there was a Fumalewski. I think that's what they called it. So yeah, hit me up, Wesley. Hit me up and I'll take care of you. I'll hook you up with a hat. Good job. Good job. Good job, Mike. Good job, young man. Disqualification provision of Section 3 attaches without congressional action. Okay, so now we have this question. What makes this Section 3 kick in that we're using it to disqualify Trump? So they'd like to challenge the Secretary's ability to certify President Trump as qualified candidate presumes that Section 3 is self-executing. Not that there's a finding that he engaged in, but that it's a finding that he engaged in insurrection, but that it's just automatically there. Just happens. In the sense that it's enforceable as constitutional disqualification without implementing legislation from Congress. Because Congress has not authorized state courts to enforce Section 3, interveners argue that this court may not consider Trump's alleged disqualification under Section 3 in a 113 proceeding. We disagree. Surprise, surprise, that we disagree with Trump. You probably thought we were going to agree with Trump, but no, we disagree with Trump on this one. The only mention in congressional power in Section 3 is that Congress may, by a vote of 2/3 of each House, remove the disqualification of a former officer who engaged in insurrection. It does not determine who decides whether disqualification is attached in the first place. So how do we know if that attached in the first place? It must be. It's automatic. Really? Interveners, however, look to Section 5 of the 14th Amendment, which provides Congress shall have the power to enforce by appropriate legislation the provisions of this article, to argue that congressional authorization is necessary for enforcement of Section 3. This argument does not withstand scrutiny. The Supreme Court has said that the 14th Amendment is undoubtedly self-executing without any ancillary legislation, so far as terms are applicable to the existing state of circumstances. Existing state of circumstances, meaning people who participate in the Civil War. It almost says, it's almost implying just the opposite of what this court is finding. But okay, let's go. And there's the civil rights cases which came out in 1883. So let's understand a little context here. Okay, 14th Amendment, which came out in 18. When was this? When was the 14th? When was the 14th Amendment? Someone tell me. Someone look that up. When was the 14th? When was the 14th Amendment drafted? 1874. In the civil rights cases, the court was directly focused on the 13th Amendment, so this statement could be described as dicta. Okay? It's not the 14th Amendment at all. But an examination of the 13th, 14th, and 15th Amendments, an interpretation of them supports the accuracy and broader significance of the statement. If you're going to attach a broader significance to the statement, it's the existing state of circumstances as of when it was drafted. It's such a stupid way to read this. It's like how, I don't know how they managed to get their ankle like behind their shoulder like that. It's amazing flexibility that this court has. Section 3, 1867, 68. Okay. Section 3 is one of 4 substantive sections of the 14th Amendment. So in Section 1, says no state shall make or enforce any law which shall abridge the privileges and immunities of citizens. So why are we giving you all this? It's saying no person shall. Representatives shall be apportioned among the several states. No person shall be a senator. Validity of the public debt of the United States shall not be questioned. Okay. Section 5 is then an enforcement provision that applies to each of the substantive provisions. And yet, Supreme Court has held that Section 1 is self-executing. Oh my God. Oh my God. Oh my God. As enacted, the 14th Amendment confers substantive rights against the states, which, like the provisions of the Bill of Rights, are self-executing, superseded by statute, religious land use, and institutionalized personalized Persons Acts of 2000. Thus, while Congress may enact enforcement legislation pursuant to Section 5, congressional action is not required to give effect to the constitutional provision. Oh my God. Wow. 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 This is your best legal thought? These are the top legal minds of Colorado. Okay. Look, maybe they know better and they're just very poor at drafting. It's possible. The benefit of the doubt is that they're very poor drafting rather than that they're utterly incompetent in their thinking. Because I haven't looked at this other than what we're reading here, what they're presenting. The Supreme Court, just understand, has said 14th Amendment is undoubtedly self-executing. Meaning, so let's understand, those of you who joined late, you need to understand what it is when we're talking about this whole self-executing thing in the analysis of the court here. So the claim by the petitioners is that Secretary of State, you're not allowed to put him on. You're not allowed to put Trump on because perhaps. You're not allowed to put Trump on because he's disqualified under Section 3 of the 14th Amendment, which says that if you swore an oath to uphold the Constitution and then you engage in insurrection, you're no longer eligible to be president of the United States. So let's just pretend for a moment that it applies to president, and that the president at the time of the oath and the time of the later office, let's pretend it says that and assume that that's all fine. Okay, we can put that aside for a moment, even though I think that's a ridiculous read and the district court thought it was a ridiculous read, but let's just put that aside for a moment. Whoever this applies to, is it something that automatically applies to them? Or there has to be some sort of finding by Congress that, hey, these folks here, they're disqualified. There's have to be some sort of finding in order for that disqualification to kick in by Congress. So, well, Supreme Court said, so if it automatically attaches, in that case, the moment Trump took the action that was engaged in insurrection, he automatically became ineligible. Okay? The moment he incited insurrection, which they're assuming that that's engaged in insurrection, which that's another legal issue that we'll come to shortly. The moment that he did it, he, boom, magically becomes ineligible without anything further happening. That's what the 14th Amendment does under Section 3. If you call it self-executing. If it's not self-executing, let's assume, for example, let's pretend there was something in the Constitution that says any person who commits murder cannot be president, which it does not exist. You can commit murder and still be president of the United States. But let's assume there was something like that. Or let's say anyone who ever kills a human being, forget about murder, okay? Anyone who ever kills a human being, they become ineligible, because I don't want to get into the whole murder versus killing. Okay. So, and someone walks over someone else, boom, pops him in the head. At that moment that the person drops dead, you killed him, and boom, now you're ineligible. Or self-executing. Or does that have to be a legal finding that you actually killed him? Or does it have to be after a legal finding that you killed him? Does there have to be a follow-up saying, because you killed him, now you are now not eligible? Those are three different ways that you could read such a thing. So now here we're dealing with this thing. At what moment does someone who loses their eligibility, someone who becomes ineligible, what moment are they becoming ineligible? So if you say it's self-executing, then you say the moment Trump issued the speech, even before they stormed up there, he was inciting an insurrection, and hence he became ineligible to ever run for office ever again. So he said the Supreme Court says undoubtedly self-executing without ancillary legislation. I mean, you don't have to have any other laws by Congress, so far as its terms are applicable to any existing state of circumstances. Those last 5 words, any existing state of circumstances, are very, 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 very pivotal. Because we need to look at the backdrop in which this is being drafted. It's 1868. We just ended the worst conflict in American history called the Civil War. And we have all these different things we're trying to figure out. What do we do with these stinking Southerners who now think that they're going to come back to Congress after they basically did all the stuff that they did? We all know that they engaged in insurrection. After they swore they're going to uphold the Constitution, next thing you know, they're firing on Old Glory. They're firing on Fort Sumter, and they're storming up here in the Battle of Bull Run and kicking our butts left and right, which is why it properly should be called the Battle of Manassas evermore after, because let's face it, to the victor go the spoils. But then I guess later on we won. So since we won, so we're able to change it back to Battle of Bull Run. Whatever you want to call it, doesn't matter. You got your Battle of Vicksburg. You got all sorts of Gettysburg, wonderful, terrible tragedy, tragic human losses. But we know that they did all these terrible things. So with respect to the existing state of circumstances in 1868, is there any further need to say, oh, Robert E. Lee, you swore an oath and then you fought against us, so you're ineligible. Oh, Stonewall Jackson, you're ineligible. Jefferson Davis, you're ineligible. Or is it automatically self-executing? So we say, oh, it's definitely self-executing with respect to any existing state of facts in 1868. But was there an existing state of circumstances with respect to whether or not Trump engaged in insurrection back in 1868? Was there some time traveler that came back and they went back into there and did a little thing like Snape, and they're turning the thing a few times. Next thing you know, oh, there's Hermione showing up here saying, hey, by the way, when you're drafting this, just bear in mind that one day Trump is going to give a speech that's going to get some people like riled up, and then some glowies are going to say, hey, let's go in there. And the next thing you know, everyone's going to start calling him an insurrectionist. Oh yeah, well, we definitely want to keep him out of office also. That's not existing state of circumstances. So it's only self-executing with respect to an existing state of circumstances in 1868. But it's certainly not self-executing if it's not existing state of circumstances in 1868. But these weed lovers in Colorado who is sitting there in the highest court in the land, they're like, oh, clearly this is self-executing, because after all, it's unbelievable. It's unbelievable. Section 2, moreover, was enacted to eliminate the constitutional compromise by which the enslaved person was counted as only 3/5 of a person for purposes of legislative apportionment. Okay. The self-executing nature of that section has never been called into question because that was an existing state of facts. By your logic, then nothing in the 14th Amendment should actually happen. It should be completely ineffective afterwards. Existing nature of the section has never been called into question, and the reapportionment following passage of the 14th Amendment, Congress simply treated the changes having occurred because their existing state of circumstances. My God. Similarly, Congress never passed enabling legislation to effectuate Section 4. Okay. It's like Tipsham, Chamor. Why don't you at least find some federal case anywhere, which establishes that it's self-executing with respect to something that happened after 1868. That was not an existing circumstance in 1868 in any regard, even if not Section 3. This is so aggravating. We're surrounded by idiots. Same is true for the third. And by the way, here's the thing. I got to tell you something. I don't think it's actual incompetence. I think it's practiced incompetence. It's like they're so blinded in their perspective that it's like they can't even. It's like any way that they can try and twist something into like coming to the preconceived conclusion. That's how they're going to try and twist it. So logically, if everyone went home on January 6th, Trump would still be ineligible. Am I getting this right? I need to spend more time in Colorado. Yes. Yeah, that's right. Because of the words that he said. Because the words he said. Before anyone went in there, he became ineligible, according to them. Yeah. If he said, we're going to march peacefully and patriotically, and everyone said, nah, I don't want to do that. I think it's cold. I'm going home. Yep. He would have been ineligible. By their logic. Yeah. Eugene V. Debs was an Atlanta penitentiary serving 10-year sentence when he lost the 1920 presidential election. I'm not sure how that's relevant here, Allegan. Oh, because I said earlier that you can commit murder and still be eligible. Yeah, that's true. Same is true for the 13th Amendment, which abolished slavery and involuntary servitude. Section 1, who cares? Who cares? Shall exist with the United States. Discussing this amendment, the Supreme Court recognized that legislation may be necessary and proper to meet all the various cases and circumstances be affected by it, but that by its own unaided force it abolished slavery and was undoubtedly self-executing without any ancillary legislation to all existing circumstances. Like the other Reconstruction amendments, 15th Amendment, which established universal male suffrage, contains a substantive provision: the right of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude, followed by enforcement provision. Congress shall have power to enforce this article by appropriate legislation. Okay. As with Section 1 of both 13th and 14th Amendments, Supreme Court has expressly confirmed the 15th Amendment is self-executing. Okay. And still it requires interpretation as to when something is considered to be abridging someone's rights. There's no textual evidence that Congress intended Section 3 to be any different. No, it's just that you're ignoring what they said about Section 3. That it's got to be any existing circumstances. Furthermore, we agreed with the electors that interpreting any of the Reconstruction amendments, given their identical structure, as not self-executing would lead to absurd results. Really? If these amendments require legislation to make them operative, Congress could nullify them by simply not enacting legislation. The result of such an action would mean that slavery remains legal. Black citizens would be counted as, oh my God. Self-executing as with regard to any existing circumstances in 1868. I was convicted under the Espionage Act. I'm not sure why you're pulling me into this other issue. Oh, you said earlier, SCOTUS will punt primary is party election. Then why would that make them punt, Allegan? How did I miss this earlier? How did court address primary as party election and not election for office? I can't start reviewing this, brother. In short, I mean, I went through this for like, I don't know, an hour and a half already. But in short, they basically said that You can't ignore the Constitution when you're putting them on. And the Secretary of State has an obligation to uphold the Constitution or to ensure that their residents have someone who's eligible under the Constitution. All right. Any individual engaged in insurrection against government, blah, 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 all this other stuff. They're saying literally the same thing over and over again. Interveners argue that certain historical evidence requires different conclusion in Section 3. We generally turn to historical and other extrinsic evidence only when the text is ambiguous, which it's not here. Nonetheless, we consider the historical claims in the interest of providing a thorough review. Interveners first highlight a settlement Representative Thaddeus Stevens made during congressional framing debates. That Section 3 will not execute itself, but as soon as it becomes a law, Congress, as the next session, will legislate to carry it both in reference to presidential act and all other elections. Well, that seems to imply other than what you're saying. The meaning and ambiguity of Section 3 of the 14th Amendment. That's their citation. But as one of the amici points out, statement referenced the deleted portion of Section 3 that disenfranchised all former Confederates until 1870. In any event, given the complex patchwork of perspectives and intentions expressed when drafting these constitutional provisions, we refuse to cherry-pick individual statements from extensive debates to ground our analysis. Oh, okay. Well, then we're going to be curious to see how you come up with the whole president thing. I want to make a little note of this right here. I want to take a picture of that part. I'm going to see if they stick to this later, because I got a feeling they're not. My gut's telling me they're not. So I'm going to take a little picture of this. Bam. We'll call that no cherry picking. All right. Interveners. Next, direct us to the non-binding opinion written by Justice Chase while he was running circuit. There, Griffin challenged his criminal conviction as null and void because under Section 3, the judge who had entered his conviction was disqualified from holding judicial office, having formally sworn a relevant oath as a state legislator and then engaged in insurrection. It was undisputed that judge fell within Section 3's scope, but question Chief Justice Chase sought to answer was whether Section 3 operated directly without any intermediate proceeding, whatever, upon all persons of category of prohibition, as depriving them at once and absolutely of all official authority and power. In interpreting the scope of the provision, Chase observed that after the end of the Civil War, but before the 14th Amendment was ratified, many southern states had established, with approval of the federal government, provisional governments to keep society functioning. And within these provisional governments, many offices were filled with citizens who would fall within Section 3. So Chase observed that giving Section 3 a literal construction, as Griffin advocated, would annul all official acts performed by these officers. He reasoned that it would be impossible to measure the evils which such construction would add to the calamities which already fall upon the people of these states. So Chase turned to what he termed the argument from inconveniences, an interpretive canon that when faced with two or more reasonable interpretations, the interpretation is preferred which best harmonizes the amendment with the general terms and spirit of the act amended. He then explained that while it's not improbable that one of these objects of this subsection was to provide for the security of the nation and individuals by the exclusion of class citizens, it could hardly be doubted that the main purpose was to inflict upon the leading most influential characters who have been engaged in about an exclusion from office. To find the provision self-executing under those circumstances, argue, would be contrary to the due process because it would once be deprived. So, what are they getting from all of this? They're saying Chase therefore concluded that the object of the amendment to exclude from certain offices a certain class of persons was impossible to do by a simple declaration, whether in the Constitution or the Act of Congress. In other words, okay, for in the very nature of things, he must be ascertained what particular individuals are embraced by the definition. To accomplish this ascertainment and ensure effective results, enforcement decisions are indispensable, can only be provided for by Congress. Thus, Chase concluded Section 3 was not self-executing. Okay. And how does that not apply? So what they're basically saying is, well, the reason Chase said in that particular case it's not self-executing is because it would have made things really terrible, really terrible, really terrible if we if we if in that area we allowed it to be self-executing, because you sort of need to have some governing people there, and some of them are going to have to participate in the Civil War, so you sort of need to let them have some sort of relative power. So let's just read it as not being self-executing, and there in that way they'll be able to like actually self-govern down in the South where you got all these Southerners. So that's why in that context he said, let's try and give it its overall effect. So what about over here? So when you apply that here, and the only way to give this effect is to abridge Trump's basic civil rights to due process, it's also ineffectual. Twisted people. Griffin's case concludes that congressional action is needed before Section 3 disqualification attaches, but this one case does not persuade us of the point. Of course it won't. Of course it won't. Interveners and amici assert that Griffin's case remains good law, been repeatedly relied on because the case is not binding on us. The fact that it has not been reversed, no particular significance. The case that's cited, so either with no analysis or for the opposite position that Section 3 does not create self-executing cause of action. Moreover, Griffin's case has been subject to persuasive criticism, like Magliocca, the guy who testified. Okay. We're getting into the whole Magliocca element. You're relying on Magliocca. This, now that we're getting to Magliocca, a lot of you are probably saying, who the heck is Magliocca? I'm going to show you who this guy is. I know this guy. I know this guy. Professor Magliocca, expert in Section 3 of the 14th Amendment. When I say expert, I'm saying expert because that's how he was qualified. Longtime expert who first started studying it after 2020 and wrote a couple of columns on it. This is Professor Gerard Magliocca. Now, this expert who the Colorado Supreme Court says we need to trust this individual, their opinion, their findings. He came in and he testified as an expert witness as to what the meaning of various words in the 14th Amendment should be understood. What makes him an expert? He wrote certain articles. When did he start writing these articles? Well, after January 6, 2021, when he started pitching for a claim that, hey, we might be able to use Section 3 of the 14th Amendment as a basis to keep Trump from running for re-election. All of a sudden, he wrote 2 articles, which a couple of his peers say, oh, yeah, I like that thinking. And now that made him now qualified as he became the expert. So this widely renowned expert, Magliocca, what was the purpose of his testimony? And I touched on this briefly earlier. I said I'm going to come back to this later. And now's the time when I'm coming back to this because I watched this guy testify. I watched him testify. And he was cherry picking and trying to figure out why it is that this case with Salmon Chase shouldn't apply and whatever. And as I was watching this testimony, I was very, very, very bothered. The reason I was very bothered is because, as I explained, I don't know, probably 2 hours ago by now, when a witness comes in and testifies, they're supposed to be testifying about fact, not about law. This is a very important distinction in the eyes of the court. Attorneys appreciate this distinction. Judges appreciate this distinction. It's much harder for laypersons in general to appreciate this distinction. So if you're having trouble understanding that fine line, do not feel like you're at all incompetent or alone, because we spend a great deal of time trying to develop an understanding as to where that line is between issues of fact and issues of law. Okay? So, a jury is supposed to be determining an issue of fact. And a bench trial, like this Section 113 proceeding was, the judge is sitting there as a trier of fact. Now, she might make issues on issues of law as well at the same time, wears two different hats, but the findings she's supposed to reach are about findings of fact. So when someone comes in and testifies, they're supposed to be providing evidence, factual evidence, not claims where they're sitting here saying the law says that in Colorado or in the United States, this is what the law is. That is precisely what they're not allowed to testify about, because that's ultimately supposed to be argued by the attorneys for this side, the attorneys for that side. There's no expert in the law that's supposed to be telling this judge and enlightening the judge what the law is. That's just not the way we do things at a trial. So this guy comes up there and he starts trying to explain what an officer meant in 1868 and the different ways that the word office was used or officer was used, and what the meaning of this phrase was, and what makes something, and how it was interpreted, whether this was supposed to be, whether in a historical context they were thinking that it's applying to a president versus not applying to the president. And he was making the whole claim that obviously was even some discussion. This is, remember a few minutes ago when I said the whole cherry picking thing? So he basically said, you know how I know that this was that Congress in 1868 meant to apply this to the president? Because there was even a question saying, hey, why don't we write the president in there? And there's a response from someone saying, oh, well, it says officer. And when it says officer, that implies president. And that was the end of the conversation. And he cherry-picked that exchange. He cherry-picked that exchange to say, that's how we know that officer means president. Of all the dialogues that happened with dozens of senators, members of the House, all debating about this amendment, that if not hundreds, that's the one thing he cherry picked. And I'm confident that this court is going to rely on that cherry pick when they come to the whole issue as to whether or not this statute references the president of the United States when it says officer. But here's the thing. He was refuted by other experts, and he's attesting to issues of fact. Do you want to know the one thing that this Supreme Court of Colorado is not allowed to do when they're making decisions about the findings of whether they're going to affirm or reverse the trial courts? They cannot reject the findings of fact made by the trial courts. So, Judge Wallace heard from this funny-looking dude, and then heard, you can call him Magliacca, you can call him Nosferatu, you can call him, Dr. Ears. I don't care what you call him. You can call him freaking Sherlock Holmes for all I care. I don't care. But Judge Wallace heard his testimony, and then heard the testimony from Trump's experts, and came to one conclusion, which is this guy is wrong. His testimony about findings of fact is wrong, flawed. And that's why Section 3 of the 14th Amendment does not apply to the president. That is the finding of fact from the trial courts. And a finding of fact from the trial courts cannot be overturned by the Colorado Supreme Court. Yet, here comes along our wonderful Colorado Supreme Court, and they're saying, oh, you know how we know who we should trust here? Because that's what Magliacca came in and told us about. Are you redoing findings of fact? You have authority? You have jurisdiction to do that? Under what basis? What appellate court has a basis in law to start reassessing findings, determinations of fact made by the trial courts? In what state in this country is that even possible? But here they are, so desperate to find any basis to say Orange Man bad, he's not on the ballots, that they're basically now saying, oh, well, let's look at what Magliacca said. I hope that was clear. I know that was a little complicated, but I hope that was clear. Go Joe. Go Joe. It's a birthday. It's a birthday. The Michigan party pays for primary. It's a party election. Allegan, I love you, dude. Go back and watch. I spent seriously 2.5. I'm 2 hours and 50 minutes into this, and I spent like well over an hour and a half addressing this. So I can't. It's not fair to everyone else. Joe, will you go over the dissent's opinion tomorrow? I don't know if we're gonna get there. I might even get there tonight. We'll see. SCOTUS will use laches to punt this. Cases to early primary is party election, not election for president of the United States. Okay, I don't know how they're going to use laches to punt this. This point doesn't make any sense at all. The reason it doesn't make any sense at all, first of all, if anything, it wouldn't be laches means is you waited too long. You might say ripeness, that it's not ripe yet to punt it, which that doesn't make much sense either, because one of the things that this court itself, this twisted, convoluted, this pretzel court of the Supreme Court of Colorado, what they basically said is, we're not even letting it go into effect until we're staying this until such time as SCOTUS makes a decision. So for SCOTUS to say it's not ripe or it's laches, it's too late, seems difficult to conceive. So you might have fears. They might say we don't want it. They don't have to say laches to punt. They can just say we're denying cert if they really don't want it. They're allowed to do that. They don't have to take this case. I don't think they will, though. I think they're going to grant cert. Ding, ding. Oh, you're welcome. Oh, thank you. Chininator. Yeah. How many people remember Turner Gill to Irving Fryer? I don't know how I missed that earlier. All right. Make sure I didn't miss anything here. For all I know, somebody said something over here. Tea with honey. Tea with honey. Beak says, Joe, can you explain Mary Cedar's super chat? What would it mean if the Republican Party withdrew as a party and went pure caucus? See, that's a very good question, and I'm not. I want to be honest with you. I'm not even sure what the ramifications of that are. What are the ramifications? That's a very good question. Oh, they're held on a local level rather than a state level. I guess that would remove it from the Secretary of State's authority. Brian says I'm grabbing a sandwich and the attic and I read a book that never ends. All right. All right. So here they are. They're saying that, well, Magliacca doesn't really like Griffin's case. Joe, watching the whole time, is ripeness for punt. SCOTUS will take, but give narrow decision on primary election, not the general. All they have to see, the question is the basis on which they find. They can say that the 14th Amendment doesn't apply to the president. They can say it's not self-executing. It has to be a finding. They can say that none of this would apply. None of his actions can't be found guilty of insurrection for engaging in incitement. That incitement doesn't qualify as engaging in insurrection. They could say that there's no basis for him to be charged with engaging in insurrection. That no charges have ever been brought against him that he engaged in insurrection or that he even engaged in incitement. They can knock out. But that's what I'm saying is you're speculating as to what SCOTUS is going to do, and we all want to know what SCOTUS is going to do. I want to know what SCOTUS is going to do. We all want to know what SCOTUS is going to do. Anyone tells you they know what they're going to do is ridiculous, because nobody knows what's going to happen there. I'm simply saying, I think this is more likely. You ask me my opinion as to what's more likely. I'll tell you what I think is most likely. So they might. You're saying they're going to use ripeness on the election because we don't know that he's going to end up being on the thing. So you can basically say that in order for 14th Amendment to kick in, it actually has to be a determination that someone has engaged in insurrection. It's not self-executing. And if that happens, yeah, that applies to the primary, but also would apply to the general election as well. That's what I'm saying, is like speculating about the impact that's going to have. It's so premature that it's ridiculous for any of us to speculate. I don't even think members of the Supreme Court themselves know how it would ultimately turn out. I mean, I don't think any individual member of the Supreme Court, I don't think Chief Justice Roberts himself knows how it would turn out right now. Maybe they've talked about it. I don't know. Perhaps they have. So for us to sit here speculating about it seems kind of, it's like speculating about what I'm going to bid on how many dollars and cents I'm going to bid on something on The Price is Right, and I don't even know what that product is yet. Like, I'm going to bid $847.26. Like, on what? Oh, I don't know. Is it a grill? Is it a lawnmower? Is it a lazy boy? That's what I'm betting. And 26 cents? Oh, yeah, definitely 26 cents. Not 28 cents? No, I don't want to overbid. Like, what? What does that even mean? It's crazy. All right. Although we do not find Griffin case compelling, we agree with the Chief Justice Chase that it must be ascertained particular individuals are embraced by the definition. While disqualification of Section 3 attaches automatically, Bubala, Sadical, was heist. I don't understand. Bajcik. Primary is party election. They can decide on that only. Yeah, they could. Okay, you're right. They could decide that. That could happen. They could ignore the 14th Amendment entirely. Yeah, that could. I'm changing my Price is Right bid from $847.26 to $853.19. How does anyone know? How do you think you know? While Section 3 attaches automatically, the determination that such an attachment has occurred must be made before its qualification holds meaning. And Congress has the power in Section 5 to establish a process for making that determination. So it attached to Trump automatically, but the determination that attached has to be made. Okay. The fact that Congress may establish such a process does not mean its qualification pursuant to Section 3 can be determined only through a process established by Congress. Okay. Here, Colorado legislature has established a process. How do you come up with their authority to do that? A court proceeding pursuant to Section 113 to make determination whether a candidate is qualified to be placed on the presidential primary ballot. See, this is the part where they're just literally just writing in now they're just writing in languages that make no sense at all. Yes, I understand Texas versus Pennsylvania punt. I understand the cowardice they displayed. How is that relevant here? I'm going to point out to you the most crystal clear way that is not relevant here. You can sit there and say, the reason that happened is because they hate Trump. Or you could say, the reason that happened is because they were terrified about the ramifications of overturning what was widely accepted as being a proper election. That is a completely different scenario. Because the level of cojones that was being called upon by them in that context to overturn what had been deemed and publicly paraded as being the will of 81 million voters and say, we're knocking out those 81 million votes and saying, we don't care about that. That requires brass cojones that the cucks sitting there in Roberts, Kavanaugh, and Barrett, that they didn't have the cojones to actually stand up there and be like, I'm not overturning that election. That is very different from saying, we're not letting you keep someone off a ballot. It's not even the same. It's not even the same ballpark. It's not even the same conversation. I understand that the effect you could say is the same as to whether or not he's president or can be president or whatever, but it's not at all the same conversation. In an era of institutional mistrust, the Colorado Supreme Court had the water on the brain level intelligence to do this. Probably handed Trump the win. I said this is probably good for Trump. Robert's institutional simp, there's no way he won't nuke this from orbit to otherwise nullifies his precious legitimacy. I agree with you. I think this is terrible. They're basically saying, oh yeah, every state could do whatever the hell they want with anybody running for office. It's ceding so much power to the state courts. And this is the type of joke. This paragraph have highlighted right here is the type of joke that would, I'm sure that Roberts, if he sees this, he'd be like, you're out of your freaking minds. This is what they're saying. Listen to what they're saying here. The fact that Congress may establish such a problem. What are they talking about here? What are they talking about? They're talking about, okay. What do they say? Section 3. I'll just break this down for you in like English terms. So they say, okay, Section 3 of the 14th Amendment, that does attach automatically. But how do we know if it's attached? It happened the moment it happened. But how do we know that it attached? Well, there has to be some sort of finding that it attached. There has to be some sort of determination that it attached. So that stain covered him the moment he made that speech, according to the Colorado Supreme Court. It covered him that moment. How do we know that this was a stain, that he crossed over into engaging in insurrection? Well, there you need to have a trial for that. You need to have some sort of court proceeding. Well, or how do we know it happened? So this is how they explain how do we figure out that it has happened. So he says that determination that such an attachment has occurred must be made before the disqualification holds meeting. So you're not disqualified until there's a termination. Okay, well, who's making that determination? Congress, under Section 5, has the power to establish a process for making that determination. But just because, so now Congress has that power, but they never really came up with a way to do that. The fact that Congress may establish such a process does not mean that disqualification pursuant to Section 3 can be determined only through a process established by Congress. Here, the Colorado legislature has this, they came up with their own process, a court proceeding under 113 to make determination whether candidates qualified. So they came up with that process. Now, was that section 113 clearly supposed to be anything in any way related to 14th Amendment? Hell no. No one ever thought such a thing when they wrote the damn thing. But they came up with a process that we're now interpreting applies in that type of circumstance. So they came up with a process for this circumstance. This is a double knot pretzel. Oh my God. And for the reasons we already explained, the process is sufficient to permit judicial determination whether sex creates qualification as that particular individual. We are simply unpersuaded by interveners' assertions because there's nothing bad orange man could have told us to help us reach any other conclusion other than keeping him out. So we're unpersuaded. The statute makes it a crime to assist or engage in any rebellion or insurrection against the authority of the United States. True. With that enactment, Congress criminalized the same conduct that is disqualified under Section 3. All that means, however, is that a person charged and convicted under 18 U.S.C. 2383 would also be disqualified under Section 3. It cannot be read to mean that only those charged, convicted, and violating the law are unconstitutionally disqualified from holding future office. So anyone who engages in rebellion or insurrection is, without having made an oath prior thereto, is invalid under 1994 2383. But this is another way they can be made invalid. In summary, based on Section 3's plain language, very plain language. We don't know why anyone even had such a question. It's so plain. It's so obvious to us. So crystal clear. Supreme Court decisions declaring it neighboring, parallel Reconstruction amendments, self-executing, and the absurd results that would flow from the interveners reading. We conclude that Section 3 is self-executing in the sense that its disqualification provision attaches without congressional action. Interveners' contrary arguments do not persuade us otherwise. That said, our conclusion that implementing legislation from Congress is unnecessary for us to proceed under Section 113 does not resolve the question of whether doing so would violate the separation powers among the three branches of government. We turn to this justiciability question next. Is it justiciable? So you might be saying to yourself, what does that mean? Is it justiciable? Is it justiciable? So let me explain to you what this is about. The word justiciable is a word you probably have not heard. It's probably not part of your everyday conversation. I say this only because it's a word I've only ever heard used prior to this context like 30 times in my life. And my life is probably far more relating to issues of law than most of yours. So, President Trump next asserts that presidential disqualification under Section 3 presents a non-justiciable political question. Again, we disagree. Surprise, surprise. In general, the judiciary's responsibility to decide cases properly before it, even those it would gladly avoid. This one we don't gladly avoid. We actually jumped into and pretended that we have some sort of jurisdiction here. The political question doctrine is a narrow exception to this rule, and a court may not avoid its responsibility to decide a case merely because it may have political implications. A controversy involves a non-justiciable political question when, as relevant here, there is a textually demonstrable constitutional commitment to the issue to coordinate political department or a lack of judicially discoverable and manageable standards for resolving it. Meaning, this question is too political for anyone to actually approach it fairly. Because whatever your politics are going to predetermine the result. The evidence is this decision itself. But since we want to give this decision, low as we are loath to wade into these waters, We are so loath to go marching and swashbuckling through the wilderness of uncharted territory, though we are loath to do it, to reach determination that Trump loses on every single legal issue that comes up. Though we are loath to do that, this is totally justiciable outside of political boundaries. Like in Nixon v. United States or Baker v. Carr, noting that the non-justiciability of political questions is primarily a function of separation of powers as identifying the above described instances and four others. Here, Trump argues that this case is non-justiciable because, in his view, Constitution and federal law commit the question of the qualifications of the president candidate to Congress. Uno momento. So I need another second here to take care of my health. I will be less than 15 seconds. All right. Trump argues the case is non-justiciable because, in his view, Constitution and federal law commit the question of the qualifications of presidential candidate to Congress. So you can't bring this. This is another element of non-justiciability, or another basis for non-justiciability, is that if it's something that is reserved for Congress alone to decide, it's outside the court's purview. They alone retain that power. The electors point out that President Trump did not argue before us the questions presented in this appeal are also non-justiciable based on lack of judicially discoverable and manageable standards, and therefore he arguably waived such argument. We nevertheless address that issue again in interest of providing a thorough review, because we're going to be very, very thorough here. No textually demonstrable constitutional commitment to Congress in Section 3 disqualification. Contrary to Trump's assertions, we perceive no constitutional provision that reflects a textually demonstrable commitment to Congress of the authority to assess presidential candidate qualifications. Okay. Conversely, the Constitution commits certain authority concerning presidential elections to states, and no way precludes states from exercising that authority. As discussed in Part B4 above, Article 2, Section 1, Clause 2 empowers state legislatures to direct how presidential electors are appointed. The Supreme Court has recognized that this provision affords the states far-reaching authority, they call it plenary authority, over presidential electors, absent some other constitutional constraint. And in furtherance of this delegation of authority, the states have evolved comprehensive, in many respects, complex election codes, regulating the most substantial ways to both federal and state elections. So, therefore, Congress basically said that states have the authority to determine who is going to run in their elections, and that they have plenary authority. The election code that we have here is an example of a comprehensive code to regulate state and federal elections. The fact that Article 2 authorizes Congress to determine the time for choosing the electors and the date on which they vote doesn't undermine the substantial authority provided to states as to how they're going to get there. In other words, just because the Constitution says that you have to have your guys show up here by date X, by January 6th, and cast their vote, doesn't mean that they didn't give us wide authority as to how those electors are chosen and how they come in there. And that's why we have our election code, which help us figure that out. I think they're probably right on this issue. In our view, Section 3's text is fully consistent with our conclusion that the Constitution has not committed the matter of presidential candidate qualifications to Congress. As we have noted, hold on a second. Although Section 3 requires a vote of 2/3 of each House to remove the disqualification set forth in Section 3, it says nothing about who or which branch should determine disqualification in the first place. Moreover, if Congress were authorized to decide by simple majority that candidate is qualified under Section 3, as President Trump asserts, this would nullify Section 3's supermajority requirement. See, this is kind of what's weird to me about the way they're drafting this. Just trying to give the benefit of the doubt here. The way that they're wording this, they're basically implying that as long as we're consistent with the Constitution, well, we can make whatever rules we want here as to how we're going to get our electors there. So we can decide that it's justiciable. We could decide how it's going to be handled. And while a disqualification has to be removed by 2/3 of Congress, we can attach that disqualification without even concerning ourselves with Congress. Moreover, Congress was authorized to decide by a simple majority that a candidate is qualified, as President Trump asserts, and this would nullify Section 3's supermajority requirement. All right. I was about to go down a rabbit hole and start raising a different issue as to states' rights with respect to putting qualifications on a president. And that rabbit hole, which I'm loath to even mention because I don't want to confuse anyone on this already twisted and confusing decision from the Colorado Supreme Court, was basically, if you're saying that you can't breach the Supreme Court's, Congress's limitations on who can go in there, they're like, but we can basically come up with our own methods as to how we're going to get those electors there. Really? What if the state legislature said, all right, yeah, we understand the United States Constitution says that if you want to run for office, you have to be over 35 years of age. But we're going to put on here that if you want to get on the ballot, you actually have to be over 60 years of age. And anyone under the age of 60 cannot get on the ballot. Let's say a state legislature decides to put forward such a thing. They're certainly going to qualify that they'll be over 35, but we're going to put a little extra hurdle in here. Our little extra hurdle is not just over 35, but they have to be over 60 if they want to get on the ballots. According to the Colorado Supreme Court, apparently their legislature is authorized to do that because their election code has plenary power. As long as it's not inconsistent with the Supreme Court, they can put in whatever the hell they want. That's how stupid their reading of this is. I mean, think about it. What's to stop any state from basically saying, "Hey, you know what? Oh, we think that you don't have to live here for 14 years, but we think you really should be living here for a minimum of 25 years. Your residency got to be for 25 years. What, 14 years? I mean, that's like a stone's throw. Well, it's got to be anything 25 years. Makes a lot more sense." Let's say, you know what? We think that if you want to be able to run, can't have orange hair. That might be discrimination. So, but let's just put that aside for a moment. Let's put that aside for a moment here. So what they're saying basically here is, we noted that Section 3 requires a vote of 2/3 of each House, that if you want to remove a disqualification, which is true. But you're the ones who are saying that it attaches automatically. Moreover, if Congress were authorized to decide by a simple majority the candidate is qualified under Section 3, this would nullify Section 3's supermajority requirement. That's only because you came to the convoluted determination that it attaches automatically. Meaning, what did this court here do in this decision? They say, well, we have a question. Does this Section 3 disqualification attach automatically? Oh, this argument this way, argument that way. Yeah, we think we want to say that applies automatically because this way this ends up being something that we can actually decide on, and we'll pretend that it attaches automatically. Now that it's attached automatically, so now Do we have the authority to be the ones to actually decide as to whether or not it has attached? Well, there's nothing saying that we can't. Now, you want to come in here and say that Congress should be able to should be the ones to decide that, but since it's attaches automatically, which is what we just decided, no one else said that. We just charted into that and said, this is what we decide. This is where we landed on that one. So now you can't, now that we came to that determination, that can only be overturned by a supermajority of Congress. Think about the audacity of this freaking court. Think about the audacity of this bizarre finding that once any judge anywhere in the country comes to a conclusion that someone is invalid under Section 3 of the 14th Amendment, any one judge comes to that determination in federal court or state court, any state judge comes to that determination that it's invalid. You know how that gets overturned? A super majority of 2/3 of the United States Congress. That's how it gets overturned. That's how it gets remedied. That's the only way. The only way you can do it. And how dare you try to trivialize that and say, oh, that could just be overturned by a simple majority of Congress. No. You need a super majority of Congress. The audacity. I mean, it's so bizarre. It's so insane when you actually think of the ramifications of what they're saying in this ruling. Any one judge of the thousands of judges across this country decide that any candidate is invalid under Section 3 of the 14th Amendment, boom. Boom. You know how that gets overturned? 2/3 supermajority of the United States Congress. Good luck negotiating with Chuck Schumer and Lindsey Graham. Good luck negotiating with Mike Johnson, Hakeem Jeffries, and AOC, Cenk Uygur, and Rachel Maddow. Go out there and get that removed. Insanity. It's insanity. This is just, it's such an insane finding. President Trump's reliance on Article 2, Section 1, Clause 5 of the Constitution, the 12th, 14th, and 20th Amendments is misplaced. We address each of those provisions in turn. Apparently, he's wrong on everything. Everything he's ever come up with, he's just wrong. Let's just face it. He's just wrong. Why? Because he's wrong. Why? Because we say he's wrong. What about the fact that you're overturning the findings of your own court? She was wrong too. Article 2, Section 1, Clause 5 provides that no person shall be eligible to serve as president unless that person is a natural-born citizen who's at least 35 years of age, reside in the United States for at least 14 years. That provision says nothing about which branch should determine whether the candidate satisfies the qualification criteria. This is such a red herring. Okay. How's that relevant to this? 12th Amendment charges Electoral College with the task of selecting candidate for president and then transmitting the electors' votes to the seat of government of the United States. It provides the procedure by which electoral votes are to be counted. Wow. This part of the argument, I'm really losing my interest in what they're saying here. They're saying here that the 14th Amendment is self-executing. Congressional action on Section 5 is not required, but any idiot judge anywhere in the country can basically have it kick in. Okay, fine. Finally, the 20th Amendment, in relevant part, empowers Congress to enact procedures to address the scenario in which neither the president nor the vice president qualifies for office. By express language, however, this amendment applies post-election, so it's not relevant. Yeah, I agree. The 20th Amendment is not really a strong point here. For these reasons, we receive no textually demonstrable constitutional commitment to Congress of the authority to assess presidential candidate qualifications, and neither Trump nor his amici, some call it amici, some say amici. I think amici sounds better. Identify any constitution. Amici basically means friends in writing, meaning that people submit briefs in support of a position. Identify any constitutional provision making such a commitment. In reaching this conclusion, we are unpersuaded by the case in which President Trump and his amici rely. which are predicated on inferences that can be can be drawn from one or more foregoing constitutional provisions of the fact the case have political implications. Okay. Section 3 involves judicially discoverable and manageable standards. All right. Let me get to a couple of these. Here. They had some type of court proceeding. Trump was trying to stand for insurrection and acquitted. Yeah, that's a good point too. Congress determined the insurrection's qualification didn't apply to Trump. That's a great point, Ed. That's a really great point. Joe, you're wrong. SCOTUS chose not to listen to the 76 million voters versus the 80 million voters when the Constitution directs SCOTUS to hear disputes between states. What I'm saying is, Joe, my point is that took far greater backbone than the likes of a Chief Roberts could ever withstand. This is far smaller backbone. This is something even a jellyfish could do. Doesn't require much backbone on this one. Not sure if this just happened 30 minutes ago, but Vic has vowed to withdraw from the Colorado ballot and call for other GOP candidates to do the same. Wow. Yeah. Vivek Ramaswamy pledges to withdraw from Colorado primary if Trump isn't put back on ballot. Is what an actual attack on democracy looks like. It's an un-American, unconstitutional, unprecedented decision. A cabal of Democrat judges are barring Trump from the ballot in Colorado, having tried every trick in the book to eliminate Trump from running the election. Bipartisan establishment is now deploying a new tactic to bar him from ever holding office again, the 14th Amendment. I pledge to withdraw from Colorado GOP primary unless Trump is also allowed to be on the state ballot. Wow. Well done. Well done, Vivek. Framers of the 14th Amendment be appalled to see this narrow provision intended to bar former U.S. officials who switched the Confederacy from seeking public office being weaponized by the sitting president as political allies to prevent the former president from seeking re-election. Wow, even Chris Christie. Well,
this came out about, let's say we've been here about 20 minutes, so half an hour ago. It's a 213-page opinion. It came out while I was in the car. I started to try to read it. Didn't get very far. But let me just say, so I can't comment on the opinion itself because I want to read it first. But what I will say is this. I do not believe Donald Trump should be prevented from being president of the United States by any court. I think he should be prevented from being president of the United States by the voters of this country. That's what I think. And I don't believe that it's good for our country if he's precluded from the ballot by a court. I think it's bad for the country if that happens. Now, the other reason I believe that is because, he will have had to incite insurrection, be a part of an insurrection for him to be excluded. There's been no trial of him on that. And while I have very strong feelings about that, as you know, I also have very strong feelings in the fact that people in this country deserve to have a trial before rights are taken away from them and deserve to have a decision by a jury of their peers before rights are taken away from them. So I know it will be counterintuitive to a lot of people who listen to me about Donald Trump. But I hope it just goes to prove you.
Because he has been like a lunatic. He's been literally a lunatic and a shill for the left. This is astonishing.
I hate him. I don't. I just think what he's done is horribly wrong and that he doesn't deserve the right.
I think you're horribly wrong.
That we would give him as voters to lead us again. But as far as the court decision, I'm not going to dump on the court until I read it. And if I think it's not well reasoned, I am a recovering lawyer. I will read it and give you my opinion, Quinn, maybe tomorrow in Portsmouth.
Well, that's why you're
but
here.
I need time to read.
All right. So that's his. Where's DeSantis? Oh, he's trying to figure out what would be best for him electorally. Where's Nikki Haley? Oh, she's also trying to reach that decision. Kudos to Vivek, who yet again, despite the fact that so many of you are terrified of him, at least says the right thing. That's a good start. That's a great start. And I'm gonna tip my cap to Chris Christie for getting the right call on this one, because I've been very, very critical of his crazy World War III inducing policies and his bizarre attacks on Trump. But at least on this one, he's enough of a man to basically take the proper position, which is, it's ridiculous for a court to strip voters of who they want to elect. Cult follow number 6, speed limit in state 65, but in this state 60. Yeah, I guess so. Person is not serving any office. I'm not sure what you mean by that. So the judicial appointments, legislative control of the executive, something seems off here. This doesn't look like the country I grew up in. Apparently, David Blackfire, Roberts will be compelled to defeat this because doing otherwise sets up a nullification crisis worse than any insurrection. If this is not overturned, and I'm saying this not as an encouragement to any of you, certainly, and definitely at this point, it's insane for anyone to resort to violence. And as I said it at the outset, and I said, early on, and I will forever say, that you want to go out there and protest this, God bless, and you should. You definitely should. You should be screaming from the rooftops about how unjust this is and how corrupt this court is and what an embarrassment this decision is. And that's why I'm walking through all the different legal flaws in this so you can better understand the legal flaws. But if you go to any of these protests and you hear anyone screaming to engage in any type of violence, understand this. Those persons are feds. You will go to jail and spend a great deal of time in prison. So do not engage in any sort of violence, because you will go. All that will end up doing is that those people who actually care about American foundational values, that there will be justification to clamp down on those crazy new insurrectionists of 2023, 2024, and it will be disastrous for you individually, as well as for those people who actually care about having a healthy republic. So I am pleading with you with the utmost sincerity, do not engage in any sort of illegal activity. Exercise your basic American rights to peacefully protest. And there's no code words, no matter what Dr. Simi might try and throw into my mouth. There's no code words, no language. It's purely that there should be loud, vitriolic protestations to this abortion of a decision from this twisted court. But all of it should be 100% peaceful for your own personal freedoms, as well as freedoms of the rest of us Americans who actually still love this country. The question of whether there are judicially discoverable and manageable standards for determining a case is not wholly separate from the question of whether the matter has been textually committed to a coordinated political department. The lack of judicial manageable standards may strengthen the conclusion of this textually demonstrable commitment. As we said, Trump has not argued for us that Section 3 lacks judicially discoverable and manageable standards, and we believe for good reason. So we're just going to throw this out there for no reason at all. This is an argument he didn't raise, but he might have raised it. But if he did, it would have been a bad argument for him to raise. So why are we talking about this when he didn't raise this? And it's a patently stupid argument that's just meant to put fluff into and to basically try to fortify our pretty hollow decision here, because it just seems like these are good arguments that we can make to show that we're acting in the right. And I'm not going to give you the courtesy of a read on this particular argument, which was not an argument that Trump even made because he thought it was a silly argument, just to give you the fun of saying that that argument is flawed. Section 3 applies to the president. Now, this is something that we've talked at length about. Now, again, those who joined late, here's the language of the 14th Amendment. It says, no person shall be a senator. What positions are you barred from holding? You can't be a senator. You can't be a member representative in Congress. You cannot be an elector of a president or vice president, or hold any office, civil or military, under the United States. Is this an office? So now, question is, doesn't say no person shall be president. Doesn't say no person shall be vice president. But what the petitioners and this court are looking to say is that hold any office under the United States or under any state. That president is an office under the United States, as opposed to being the office of the United States. And how do you get that's the punishment. You can't be that if you previously took an oath as a member of Congress or as an officer of the United States. So he wasn't a member of Congress, but he was, they want to say, an officer of the United States rather than being the office of the presidency. And then to support and took an oath in that capacity to support the Constitution of the United States, and shall have engaged in insurrection or rebellion against the same, or given aid or comfort to enemies thereof. Now, this is the Section 3 of the 14th Amendment, which is at issue here in this case. So does this apply to the president when it doesn't seem to say president anywhere here? And bear in mind that after hearing from all the different logical explanations and all the historical contexts and all those facts, Judge Wallace at the district court said, this does not apply to the president. She's about to be overruled over here on that by the Supreme Court, who are going to say it does apply to the president. The parties debate the scope of Section 3. The electors claim that this potential source of disqualification encompasses the president. Trump argues that it does not, and the district court agreed with Trump that it doesn't apply to him. On this issue, we reverse the district court. Section 3 prohibits a person from holding any office, civil or military, on the United States if that person is an officer of the United States, took an oath to support the Constitution of the United States, and subsequently engaged in insurrection. Accordingly, Section 3 applies to President Trump only if the president is an office, civil or military, on the United States, and the president is an officer of the United States, and the presidential oath constitutes an oath to support the Constitution of the United States. We address each point in turn. Walk us through it. Give it to us. Give it to us, Sally. We want to hear your thoughts. Okay. The district court concluded the presidency is not an office, civil or military in the United States for two reasons. First, the court noted that the presidency is not specifically mentioned in Section 3. Those senators, representatives, presidential electors are. The court found it unlikely the presidency would be included in a catch-all of any office of the civil or military. Second, now, but understand this, that was pursuant to a finding of fact. She listened to factual evidence in reaching that. This was an issue, understand that this was a legal issue that was raised before the trial. And the court said, I need to know more facts before I can actually come to a determination on this. And relied on the factual evidence presented through expert witnesses to reach a conclusion this is not applying to the president. Second, the court found it compelling that an earlier draft of this section specifically included the presidency, suggesting the drafters intended to omit the presidency in the version that passed. We disagree with the district court's conclusion, as our reading of both the constitutional text and the historical record counsel that the president is an office under the United States within the meaning of Section 3. You're arguing about the factual parts now. You're not supposed to be arguing with the trial court about that. When interpreting the Constitution, we prefer phrases normal and ordinary usage over secret or technical meanings that would not have been known to ordinary citizens of the founding generation. Dictionaries from the time of the 14th Amendment ratification define office in a particular duty, charge, or trust conferred by public authority for public purpose. Well, then it also would imply senator. Why would you have to say senator? It would imply member of the House. Could have just said any officer. That is undertaken by authority from the government who administer it. Why the hell do you think it says senator? If you really think this is what it means, why doesn't it just say no person shall hold any office, civil or military, on the United States? And leave out all these other folks. Leave them all out. Why do you think it's there? That's a pretty good question, right? A particular duty, charge, trust conferred by public authority and for public purpose that is undertaken by authority from government or those who administer it. The presidency falls comfortably within these definitions. We do not place the same weight on the district court did on the fact that the presidency is specifically mentioned in Section 3. It seems most likely that the president is not specifically included because it is so evidently an office. Wow. Wow. You are retarded. You're idiots. You're stupid people. That you think that this is a logical conclusion. You're literally stupid people. I mean, it seems most likely the president not specifically included because so evidently in office that it's listed. If it's so evidently in office, then why the hell would it not be before senator? In fact, no specific office is listed in Section 3. Instead, the section refers to any office, civil or military. True, senators, representative presidential electors are listed, but none of these positions consider an office in the Constitution. Instead, senators and representatives are referred to as members of the respective bodies. Oh, so they couldn't put members. Each house should be the judge of no person holding any office on the United States shall be a member of either house during its continuance. No senator, representative, person holding any office, trust, or profit under the United States shall be appointed as elector. Indeed, even interveners do not deny the presidency is an office. Instead, they assert that it is not an office under the United States. Their claim is that the president and elected members of Congress are the government of the United States and cannot therefore be serving under the United States. We cannot accept this interpretation because Orange Man bad. A conclusion that the presidency is something other than an office on the United States is fundamentally at odds with the idea that the government officials, including the president, serve we the people. Is it the Constitution or it's more plausible reading of the phrase on the United States that the drafters meant simply to distinguish those holding federal office from those holding under any state. But then it says under the United States or under any state. Was an officer of the United States or any member of the state legislature. What the hell are you talking about? This reading language section 3 is moreover most consistent with the Constitution as a whole. The Constitution refers to presidency as an office 25 times. Then why did you allow her to have this whole hearing? If it's such a legal issue, there's only two possibilities. Either a determination is as to whether or not office refers to presidency of the United States entails questions of fact or it does not. If it entails questions of fact about the historical nature, about the background, about the context of the drafting of this whole thing, then you cannot overturn those factual findings to reach your own legal conclusion. And if it's not a factual issue, then why the heck did you approve her going forward with this trial in the first place? And having taking any testimony on that. In fact, you lauded her work. You said she did a wonderful job. Wonderful job here. Oh, such fine work. So twisted. Maybe this is the long-term effects of 10 years of weed legalization. Could be. And it refers to an office in the United States in several contexts that clearly support the collusion presidency of such an office. Consider, for example, the impeachment clause, which reads that Congress can impose a consequence of impeachment and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. It's interesting that office there is capitalized. The O in office is capitalized. Unlike officer, well, any office. That's interesting. That's really interesting. The presidency is not an office of the United States, and anyone impeached, including the president, can nonetheless go on to serve as president. Yeah, okay, we all get the fact that in that context is referring to the president. This reading is nonsensical, as recent impeachments demonstrate. Okay, you're nonsensical. In articles of impeachment brought against both President Clinton and Trump, asked for each man's removal from office and disqualification to hold. No one's arguing that impeachment applies to him. But notice how it says any office of honor. Office of honor. With a capital O. That's your proof? God, so stupid. Surely the impeachment members of Congress correctly understood that either man, if convicted, would be disqualified. Similarly, the incompatibility clause states that no person holding any office on the United States shall be a member of either house during his continuance of office. Notice how, again, office, capital O, capital O. Oh, let's see. Why would there be a capital O? You see, now I want to pull up the entire United States Constitution and analyze it 25 times and see whether it's how many times the O is capitalized versus not capitalized. I'll do a quick search on that. So dumb. I feel like I'm surrounded by idiots. Not you guys. You're brilliant and beautiful. So beautiful. Oh my gosh, why is this taking so long to load? I need to restart my computer. Sound guy Joe is just like yelling at me. Here we go. All right, let's pull this up. Control F. Officers with capital O. Officer, 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 office, office, office of honor. Capital O, capital O, capital O, capital O. That's post officers. That's weird. Officers, officer, office, 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 office. Almost halfway there, don't worry. Office, office. Look. Oh, yeah. You know when we don't have capital O? When you get to the 14th Amendment. Crazy. 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 There you go. Hold any office. Officer. Officer. 22nd Amendment. Right here it says office of the president with a small o. This is interesting. So let's see. Office of the president. Office of president. So he's definitely referring to president. Okay. Whew. I got bronchitis. Nobody got time for that. All right. Let's get back. Trump. The best capitals. Look, it's the best capitals. It is the. No person holding an office in the United States shall be a member of either house during his continuous office. To be office under the United States to exclude presidency would mean that a sitting president could also constitutionally occupy a seat in Congress, a result foreclosed by basic principles of separation of powers. You have anywhere else that senators are listed before president? Anywhere in the Constitution? Anywhere? Finally, the Emoluments Clause provides that no person holding any office or profit trust shall, without the consent of Congress, accept any president, emolument, office, or a title of any kind. I'll tell you this. I just want to look through the rest of those offices. Because here it's clearly talking about, it's like expressly saying office of president. So maybe office doesn't need to be capitalized. We'll go further. Let's go. It's only 15 more of these. So from office. Office of the vice president. I am curious about these capitalizations. Here's duties of his office. Drive either the principal office's executive departments. This requires further diak. Okay. Any king, prince, or foreign state to read the president as something other than an officer of the United States would exempt the nation's chief diplomat from these protections against. See, this is so dumb because trying to read how officer is used in other contexts as implications of what it means here in the 14th Amendment. When in those circumstances, it must apply to the president in order for it to have any logical effect, does not really give any perspective at all as to like what it means when there has no ramifications necessarily on the president. The district court found it compelling that an earlier draft proposed section listed presidency. The version ultimately passed did not. As a starting point, however, we're mindful that it is always perilous to derive the meaning of adopt provision from another provision to lead in the drafting process. And the specifics of the change from the earlier draft to what was ultimately passed not demonstrate intent to exclude the presidency from the covered offices. Oh, that's interesting. The draft proposal provided that insurrectionist oath breakers could not hold the office of president or vice president of the United States, senator or representative of the National Congress, or any other now held under appointment from the president of the United States and requiring the confirmation of the Senate. Later versions of the section include the enacted draft, removing specific reference to the president and vice president, expanded the category of office holder to include any office, civil or military, rather than only those requiring presidential appointments. It's hard to glean from these limited available evidence what the changes across proposals meant. other than that they're specifically excluding the president. We find persuasive Amici's suggestion that Representative McKee, who drafted these proposals, most likely took for granted that his second proposal included the president. While nothing in Representative McKee's speeches mentions why his express reference to presidency was removed, his public pronouncements leave no doubt that his subsequent draft proposal still sought to ensure the rebels had absolutely no access to political power. You simpletons, you half-breed, you inbred, half-witted, dim-witted, ridiculous. These are precisely the questions of fact that the trial court concluded led her to believe findings of fact that office does not include president. The only thing you're not allowed to overturn a trial court for at the appellate level is what this court was so gung-ho to go after Trump that that's what they overturned her on. All right. Tell us about how McKee explained that under the imposed. See, they're coming into the whole factual finding. They're doing their own fact finding. They have no authority to do fact finding on this. That's what the trial court's for. McKee explained that under the proposed amendment, the law alone shall rule the country, and the traitors will be cut off. McKee desired to exclude all oath breakers. Here's your whole explanation. Here's all your facts. That's a nice little fact-finding mission you're going on here, appellate court. That's really interesting. Really interesting. Tell us more. It's really fascinating, bro. The importance of the inclusive language, any officer of civil military, was the subject of colloquy and debates around adopting the 14th Amendment. Senator Robert E. Johnson worried the final version of Section 3 did not include the office of presidency. He stated this amendment does not go far enough because past president may be elected president or vice president. So he asked, why did you omit to exclude them? I do not understand them to be excluded from the privilege of holding the two highest officers in the gifted nation. He replied, let me call the senator's attention to the words, or hold any office, civil or military. This answer satisfied Senator Johnson, who stated, perhaps I am wrong as to exclusion from the presidency. No doubt I am, but I was misled by noticing a specific exclusion. This colloquy further supports the view that the drafters of this amendment intend the phrase any office to broadly inclusive and certainly to include the presidency. Oh, yeah. I knew they were going to do it. What are they doing? What are they doing here? Oh, you know what they're doing? Yikes. That's not what I wanted. I'm going to show you what they're doing. I told you they were going to do this. I told you that this court on page 55 said no cherry picking from the whole dialogue of what's happening in senators. It's crazy to cherry pick. You can't cherry pick. And I knew they were going to cherry pick that specific quote. But that's why I took a screenshot of this right here, page 55. Did I tell you this was going to happen? Did I specifically tell you before I even got to page 79? I told you 24 pages ago that when they're saying no cherry picking now, but later on, I have a feeling we're going to see them cherry pick. They said here specifically, given the complex patchwork of perspectives and intentions expressed when drafting these constitutional provisions, we refuse to cherry pick individual statements from extensive debates to ground our analysis. That's what this decision wrote 24 pages ago. We're not going to cherry pick from isolated conversations that are happening in Congress, because when the way Trump wants us to cherry pick, we're not going to cherry pick that. Can't cherry pick. We're not engaged in cherry picking. That's not a fair way to do assessment. Oh, that's not at all a fair way to do assessment. And yet, oh, whoa, what's happening here? Oh, no, heck. Oh, no. No. We're not going to cherry pick. Of course not. Cherry picking is terrible. Absolutely verboten. But here's a colloquy that we cherry picked from the debate at the drafting of this thing, where they said, oh yeah, officer includes president. This is where you see twisted, disturbing partisan politics. This is how you know it's not justiciable. You're proving right here it's not justiciable when you can't even keep up to your own stinking standards 24 pages later in the same stupid decision that you say we're not going to cherry pick as to the language, as to the conversations that are happening in Congress when they're drafting an amendment in order to try and reach any understanding there. And then you specifically cherry pick in order to prove a different point that you weren't proven. This is where you show you're a freaking partisan hack. You're here to destroy this country with your stupid leftist agendas that you think, oh, I'm saving the world by keeping President Trump off the ballot. You are losers. You are ultimately stupid, pathetic, moronic losers. And here is your hypocrisy shown in black and white. God, that's so aggravating. Reconstruction era citizens, supporters, opponents to Section 3 alike understood Section 3 disqualified oath-breaking insurrections from holding the office of president. Who cares? Citizens and supporters, what the hell they thought. How the hell is that relevant? Oh, yeah, you know what? My milkman, he says that Section 3 of the 14th Amendment says that that Jefferson Davis can't be president. Oh, well, if Sam the milkman says that, then we know that's what it means. What a stupid claim. Citizen supporters and opponents. God. Post-ratification history includes more of the same. Congress floated the idea of blanket amnesty to shield rebels from Section 3. See, this is a whole fact-finding. They're doing a whole stupid fact-finding. Exactly what they're not supposed to engage in here. Bunch of partisan loser hacks. Talk about Jefferson Davis. We conclude, therefore, the plain language Section 3, which provides plain language. No disqualified person to hold any office under the president, includes the office of presidency. This textual interpretation is bolstered by constitutional context and by history surrounding the enactment of the 14th Amendment. You are losers. That's all you are. You're losers. Sitting in the highest judicial office in Colorado. You're a bunch of losers. Colorado, you're a bunch of... Sorry, Coloradoans. You got to move. Can't rely on Supreme Court to bail you out all the time. What are you going to do in 10 years when the makeup of the court is turnover after Thomas and Roberts are gone? Leader are gone. What you going to do then? Random capitalizations of the first three articles are just a byproduct of penmanship with a quill. It's not a grammatical style thing. Could be right. I was wondering about it. I thought it was funny. It's about as bad as 1870s Texas semicolon court. I don't know that one. Joe, they can do fact-finding. They said de novo. Not all of it was de novo. Not this part of it can be de novo. Findings of fact can't be de novo. That issue was de novo. They didn't say the standard here. They didn't apply the standard here. There's a good reason they left it out. When there's multiple issues in an appeal, each issue you address whether it's de novo or judicial error. President is an officer of the United States. We next consider what the president is an officer of the United States. District Court found. They're going to go through the same stupid analysis here. It's going to be the exact same thing over here. This is going to be part 2. This is going to be like basically a repeat of what they just said for the last 5 pages. And first, the normal and ordinary usage term officer of the United States includes president. We explained that. And we're going to just cite that all over again. Indeed, Americans refer to the president as an officer from the days of the founding. And second, Section 3's drafters and their contemporaries understood president as officer of the United States. Here's more findings of fact by them. President Trump concedes as much on appeal, stating that, to be sure, the president is an officer. He agrees, however, the president is an officer of the Constitution, not an officer of the United States, which he posits is a constitutional term of art. Further, at least one amicus contends that the above reference historical uses reference the president as an officer only in a colloquial sense, and thus having no bearing on terms used in Section 3. We disagree. The informality of these uses is exactly the point. If members of the 39th Congress and their contemporaries all use the term officer according to its ordinary meaning to refer to the president, we presume this is the same meaning the drafters intended to have in Section 3. Perceive no persuasive contemporary evidence demonstrating that some other technical term of art meaning. And this, we decided this long before this decision was even brought to us on appeal. We also find the Attorney General Stanberry's opinions on the meaning of Section 3 significant. In one opinion on the subject, Stanberry explained that the term "Officer of the United States" within Section 3 is used in its most general sense without any qualification as legislative or executive or judicial. Oh, you know who they're relying on for this? Magniaca, the very dude, the very Nosferatu that Judge Wallace said, I think you're wrong. He went at length into what Stanberry said. And in his second opinion on this topic, he observed the term "officers of the United States" includes without limitation any person who at any time prior to the rebellion held any office, civil or military. Third, the structure of Section 3 persuades the president as an officer of the United States. First half of Section 3 describes offices, and we already determined that officers includes him. So there's a parallel structure, the two halves. And once we decide the first half means president, we're going to decide that in the second half as well. So, hence, because there's a perfect parallel in structure, and once we decide that officer in the first time is referred to president, obviously, officer in the second time is being used and referred to as president as well. Fourth, which that I guess I would make sense. Once you reach your backwards finding the first time around, I can understand you coming to a backward finding on the second part of it. Fourth, the clear purpose of Section 3 to ensure disloyal officers can never again play a role in governing country leaves no room to conclude that officer of the United States was a term of art. And finally, they come to, so therefore they conclude that the officer of the United States includes the president. Finally, we consider whether the office taken by the president to preserve, protect, and defend the Constitution is an oath to support the Constitution. This is one of the issues that was raised multiple times. It came up at trial, meaning that the oath that he's giving is different than the oath that everyone else is given. Because the president's oath is to preserve, protect, and defend the Constitution, not to support the Constitution. The language in the statute says anyone takes an oath. Where are you? An oath to support the Constitution. So they're basically saying this doesn't apply to him. He doesn't take an oath to support the Constitution. He says he's going to protect and defend. I don't think that this is a strong argument for Trump personally. The reason I don't think this is a strong argument for Trump is because I imagine there probably were numerous different oaths that were being given. And I think that this language to support the Constitution of the United States is broadly meant for any office where someone's putting their hand on a Bible and swearing in to be a sheriff, to be some constable, or whatever stupid role that people had in the 1800s, not to trivialize them. But the point is a myriad of many different roles, which all of them were generally supporting the Constitution. How would you cover all those different promises? You would just say any oath to support the Constitution. So I don't think that it's to the exclusion of the president's oath. So I never thought this argument was a strong argument. I try and be legitimate with you about which arguments Trump made that I think are reasonably sound and those that I think are weaker. And this argument over here, I think is pretty weak. This argument presented by Trump's team, I think is pretty weak. So the district court found that because presidential oath language is more particular than the oath reference Section 3, the draft does not intend to include former presidents. We disagree. The Constitution provides that all executive and judicial officers of the United States shall be bound by oath or affirmation to support the Constitution. Article 2 specifies that the president shall swear an oath to preserve, protect, and defend the Constitution. Interveners contend that because the Article 2 oath does not include a pledge to support the Constitution, an insurrectionist president cannot be disqualified from holding future office under Section 3, on the basis of that oath. So, this is an interesting thing. So maybe it applies to keep out someone who swore an oath, but if it's a sworn oath from becoming president, but it cannot apply to someone who was an insurrectionist as president, which, by the way, the concept of a president being insurrectionist is kind of, but we're not up to that legal question yet. This argument fails because the president is an executive officer of the United States under Article 4, albeit one for more specific oath is prescribed. This conclusion follows logically from the accepted fact that the vice president is also an executive officer. True, the vice president takes more general oath prescribed by federal law. But it makes no sense to conclude the vice president executive officer under Article 6, but the vice president, but the president is not. The language of the presidential oath, well, you could say because he's the executive in chief, that he is different. It's not the same as vice president at all. I'm not sure why I say it makes no sense. The language of presidential oath, a commitment to preserve, protect, and defend the Constitution, consistent with the plain meaning of the word support. Like I said, I happen to agree with that claim. So the dictionaries in the time of Section 3 is drafting. The specific language of the presidential oath does not make it anything other than an oath to support the Constitution. Indeed, as one senator explained just a few years before Section 3's ratification, the language in the presidential oath of office that he shall protect, support, and defend the Constitution makes his obligation more emphatic and more obligatory, if possible, than ours, which is simply to support the Constitution. And in fact, several 19th century presidents referred to the president's oath as an oath to support the Constitution. In some, simplest, most obvious interpretation of the Constitution is, if in itself sensible, is most likely to be that meant by the people in its adoption. And the most obvious and sensible reading of Section 3 is supported by text and history, leads us to conclude president is an office of the United States. And that he's an officer of the United States, and that his oath is to support the Constitution. President Trump asks us to hold that Section 3 disqualifies every oath-breaking insurrectionist except the most powerful one. Maybe because there's no such thing as a president who is an insurrectionist. You know, like he's sort of the one who's setting the laws, so how can he be breaking them? That would be a logical thing. It bars oath breakers of virtually every other office, but state, federal, except the highest one in the land. Both results are inconsistent with plain language and the history of Section 3. Really? We therefore reverse district court finding Section 3 does not apply to president, include that Section 3 bars President Trump from holding office of president if its other provisions are met, which we know we're going to find that they are met. Before addressing the district court's findings that President Trump engaged in insurrection, however, we consider President Trump's challenge to the admissibility of a congressional report in which the district court premised some of its findings. All right. The J6 report. Let's talk about this. Let's talk about the J6 report as assessed by the Colorado Supreme Court. President Trump asserts that the district court wrongly admitted into evidence 31 findings from a congressional report drafted by the Select Committee to investigate the J6 attack on the Capitol, which recounted the committee's investigation of the facts, circumstances, and cause of the attack on the Capitol. In Trump's view, the report is an untrustworthy, partisan, political document and therefore constituted inadmissible hearsay under Rule 803(8)(c). We are unpersuaded. Surprise, surprise. Under the deferential standard, a review that governs, we perceive no error. See? No error by the district court. Why? Because that is a fact-finding issue. See, Allegan? Fact-finding issue. But the historical background is also of the meaning of the words in Section 3 is also part of her fact-finding. So the standard is judicial error, not de novo. But they didn't cover that. They didn't talk about what the standard review is. Now, all of a sudden, when they're agreeing with her, oh, that's our standard review. They didn't talk about the standard review with respect to interpreting Section 3, the words of Section 3. Wonder what would happen if elected Protestants say, I do not take oath, religious exemption. Many Christians, including Amish and Mennonite, do not take oaths. They affirm instead. Everyone is obligated to affirm. You can't go into court and testify without issuing some affirmation. An affirmation is accorded the same weight as an oath. Technically, Washington was an insurrectionist. Yeah. Really. He was dead by the time this amendment was written. So, fuel me up. $427 you watching. I'm 4 hours in here. I'm just going to show you. Because you think I'm making this up. 69. 69. 69. Like seriously. Seriously. I'm at this for 4 hours. It's 427 you watching. 69. Oh, thank you. God bless. Unbelievable. Unbelievable. You're very welcome, and thank you for your support, Brian. I appreciate you, brother. All right. President Trump's view of the report is an untrustworthy, partisan, political hack ridiculousness that it's a joke that anyone takes seriously. We reviewed district court evidentiary ruling for abuse of discretion. The court abuses discretion only if its discretion is manifestly arbitrary, unreasonable, or unfair. Yeah. Where was your abuse of discretion when you were weighing how effectual Magliacco was? We may not consider whether we would have reached a different result, but only whether the trial court's decision fell within the range of reasonable options. Hearsay statements or out-of-court statements offer the court the truth of the matter asserted. Such statements are generally inadmissible, but there's an exception for Syria 803.8, which is if it was reports of public offices or agencies setting forth factual findings. Exception, however, applies only if the report is trustworthy. So there's hearsay. Here's the exception that she relied on, but it's only applicable if it's trustworthy. Federal rules of evidence contain a near identical exception in Colorado Rule 803.8. So we look at federal case law, interpreting federal rule, guidance, and how to assess trustworthiness. And under federal law, courts are instructed to assume admissibility in the first instance. Thus, the party challenging the admissibility of a public or agency report bears the burden of demonstrating the report is not trustworthy. So we're going to assume that the J6 thing is not trustworthy unless you come forward with some sort of proof. Federal courts have identified 4 non-exclusive factors to help courts determine trustworthy: timeliness, special skill or expertise in investigating official, whether a hearing was held and the level at which it was conducted, and possible motivation problems. District court employed the foregoing presumption of 4 factors to analyze the J6 report. If the first 3 barrier factors weigh strongly in favor of reliability. Strongly? Special skill or expertise in the investigating officials? Strongly? Trump focuses admissibility challenge on the 4th factor, possible motivation problems. Not possible. Not possible. Definite motivation problems. Trump claims the report was biased against him because all 9 committee members voted in favor of impeaching him before the investigation began. Timothy Heaphy, the committee testified at trial, however, that although members certainly had hypotheses that were a starting point, such hypotheses did not impair the members' ability to be fair and impartial. You excluded people who did not vote that way. District Court found Heaphy's testimony on the subject to be credible, that any perceived animus of the committee members toward Trump did not taint the conclusions of the January 6th report in such a way that would render them unreliable. No, of course not at all. We see no abuse of discretion because we're just as biased as all those people who wrote that report. Second, Trump believes that political backdrop against which the report was created makes it unreliable. This argument proves too much. All congressional records contain some level of political motivation. Okay. Third, Trump asserts that because Democrats outnumber Republicans 7-2, report's findings are necessarily biased. District Court determined that although a report would have further reliability had been greater Republican participation, the deficit did not demonstrate motivation problems. Not at all. District Court observed the House Republicans opted to boycott the committee after then Speaker of the House Nancy Pelosi agreed to seat only 3 of the 5 Republicans recommended to her. Despite then Speaker Pelosi's unprecedented move, the District Court noted that 2 Republicans who did sit were both duly elected Republicans who swore to hate Trump forever. This is like so stupid. This is why cuck rhinos like Liz Cheney and Adam Kinzinger are more vile than the worst of Democrats, because they paint a veneer of legitimacy to complete and total dog guano. So they do. And that little veneer of legitimacy, he's even a Republican. Gross, disgusting human beings. Burn in the deepest pits of hell. The investigative staff included many Republican lawyers. Oh, yeah, okay. Staffing decisions not include any inquiry into political affiliation. Because they knew who it was. They knew who each person was. This is so stupid. This is like so self-serving. This is a court that is now bending over and giving itself fellatio. The overwhelming majority of witnesses were Trump administration officials and Republicans. The court reasoned that's the ones that came forward. The ones that came forward, the only ones they presented were anyone who said something negative. Court reasoned these facts all cut against DeVito's argument that lack of participation in the minority party resulted in unreliable conclusions. Again, we pursue no abuse of discretion. Of course you don't. Of course you don't. What's particularly impressive about this self-fellatio is that you can manage to actually find what you're fellating. Whenever the possible motivation problems, the weight of the other 3 factor remains. So, there you go. Investigative staff consists of highly skilled lawyers. Who says highly skilled lawyers are good at investigating? Including 2 former U.S. attorneys. Are they investigators? Dig up. What does that mean? Trump nonetheless argues that even the report is generally admissible under Sierra 3 exception, there were even the 11 admitted findings within the report that remain independently inadmissible. Even if the general admissibility report does not necessarily give a green light to multiple layers of hearsay, we conclude that only 2 of the 11 challenges findings constitute hearsay within hearsay. And even if there was an error in admitting those findings, neither is of sufficient consequence to warrant reversal. So the report cited newspaper articles citing that the election was called for President Biden. Although this is hearsay, the district court did not rely on the statement in its analysis. So that would be the hearsay within the hearsay. Second, the report explained the Chief of Staff, Mark Meadows, told White House counsel Pat Cipollone that President Trump doesn't want to do anything to stop the violence. The fact that this statement is hearsay is irrelevant. District Court expressly noted that it has only considered those portions of the January 6th report which are referenced in this order. Considered no other portion reaching this decision. This is a woman who voted, who donated money to an organization that was looking to censure the Colorado GOP for allowing him on the ballot. That's who this trial judge was. President Trump's embedded hearsay agreement is unavailing. For these reasons, we conclude the district court did not abuse discretion. Here we go. Let's get to this. Trump engaged in insurrection. Let's go. Let's go. Let's go. I just need a second here. Give me a second. Pull you up over here. Automoronic ass litigation. Yeah. It's a kind way of phrasing it. All right. Trump challenges the court findings that he engaged in insurrection. Constitution leaves these terms undefined. We're going to define them, though. Therefore, we have to make a legal determination regarding what the drafters and ratifiers meant when they chose to deploy these words in Section 3. Mindful of the deferential standard review afforded district court's factual findings, we conclude the district court did not clearly err, including that the events of January 6th constitute an insurrection and that Trump engaged in that insurrection. How are we going? Are we going to novo here? No. Why? And I'm not saying that they're finding that their level of review here is inappropriate, because they're reviewing her fact finding, her conclusions based on her fact finding. Review findings of fact under clear error or abuse of discretion standard. Okay. When, however, the issue before appellate court presents a mixed question of law and fact, Colorado courts have taken different approaches depending on the circumstances. For example, this is a general matter we review under fact finding and clear error, but when you have an issue of fact combined with an issue of law, there's different approaches. Courts have sometimes treated the ultimate conclusion as one of fact and applied the clear error standard. Other cases, courts conclude that a mixed question of law and fact mandates de novo review. When a trial court made evidentiary findings of fact in support of his application of a legal principle from another jurisdiction, we found it appropriate to conduct an abuse of discretion review of the evidentiary factual findings supporting the legal conclusion and de novo review of the legal conclusion itself. Boom. Boom. Read that. Remember, there are different standards of review, and the standards of review are very, they sound like a whole glom of words, but they're very, very important, because an appellate court is deciding, are we going to overturn this lower court finding or uphold it? And when you apply a de novo review, it is much easier to overturn it. When you apply a reasonable, when you're applying an abuse of discretion, what you're saying is this: unless the lower court really fouled up terribly, so that it was like, this is error of law, they abused their discretion. Even if we disagree, we think you got it wrong, but you didn't foul up, we have to let it stand. That's very different from saying, okay, we're going to pretend you never spoke at all, and now we're going to look at it, and whichever way we lean, that's what we're going to conclude. That's the difference between a de novo review versus abuse of discretion. Very, very, very different. And that's why what I'm saying is, when in Colorado, under Colorado law, when you have something that you have a legal conclusion based on fact finding, so in that case, what do? We say, trial court made evidentiary findings of fact in support of its application of a legal principle, so we split the baby. And this is logical. They say, we found it appropriate to conduct an abuse of discretion review of the evidentiary factual findings, and then the legal conclusion come de novo. And this is where the court admits without recognizing it because they're too incompetent to recognize their own admission. But here, I'm saying this right now. I genuinely believe that this trial court is so twisted by its bias that they don't recognize the hypocrisy of what they wrote in this paragraph compared to what they did 15 pages earlier. Because they are admitting that the standard of review, when you have a new legal issue supported by factual findings, is a split. And for the factual findings, you have to go by abuse of discretion standard. And whatever the court says, unless they really fouled up, you got to go with what the court found on those fact findings. Once you have those findings of fact, then you apply that de novo to, okay, now these are what the facts are. What's the law, given these facts being true? So here, when it comes to this issue, all of a sudden the court starts articulating, oh, we're trying to figure out here as far as did he engage in insurrection? Well, this is a new issue of law. So what we're going to do is we're going to give her wide latitude about her findings of fact and then see, okay, once we accept your findings of fact pretty much as being true, unless you completely fouled up, now we're going to apply that to the rule of law. A fresh face on rule of law in these facts that we say you got right. We assume you got your facts right. That's how they're doing this here. What about interpreting Section 3 of the 14th Amendment, which was a combination of fact-finding leading to a legal conclusion? The fact-finding was being done at the lower court, unless Judge Wallace completely fouled that up. Whatever she decided, that's the finding of fact, as this court admits right here, that when you have a fact finding combined with that, it's appropriate to conduct an abuse of discretion review on evidentiary factual findings that support the legal conclusion. Which means that when Judge Wallace came to a fact finding conclusion that as to what the meaning of the word officer is, does that mean president? Does it not mean president? Unless she fouled up as a matter of law, this court has no authority, no jurisdiction, no leg to stand on as to what it is, as to whether or not she got it right. And no basis to overturn her, unless they are so twisted with vile, venomous hatred toward Trump that they literally ignored the standard that they themselves espouse here on pages 96 and 97 of their own stupid decision. Let me screenshot that. Save that. All right. Easy. Next 25 pages, they believe J6 committee, and it's all true. No, that's not what they're saying. They're not believing the J6 committee report. They're believing her, which actually makes sense. They have to believe her. That makes sense. They're going to pin it all on Judge Wallace. That was her findings. That actually makes sense. Unless there's clear error of review in the application. For our purposes here, we are calling to review the district court's construction of certain terms used Section 3 to establish to the facts established by the evidence. We review the district court's factual findings with clear error and its legal conclusions de novo. All right, dictionaries. Here we go. Let's start figuring out what these different terms mean. The word insurrection, for example, Webster from 1860 defined insurrection as a rising against civil or political authority, the open and active opposition, number of persons, and to the execution of law in a city or state, It is equivalent to sedition, except that sedition expresses less extensive rising of citizens. Differs from a rebellion, for the latter expresses a revolt or attempt to overthrow the government to establish a different one, or to place the country under another jurisdiction. Okay. Webster's Third New International Dictionary defines insurrection as an act or instance of revolting against civil or political authority engaged or against an established government. So based on these definitions, so what's an insurrection? It's a public use of force or threat of force by a group of people to hinder or prevent execution of the Constitution of the United States. Finally, we note that the oral argument of President Trump's counsel, while not providing a specific definition, argued that insurrection is more than a riot but less than a rebellion. We agree. Insurrection falls along the spectrum of related conduct. Okay. I'm not going through there. But we part company with him when he goes one step further. No authority supports the position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve a particular length of time or geographic location. Really? Although we acknowledge that these definitions vary and some are arguably broader than others, for example, for purposes of deciding this case, we need not adopt a single all-encompassing definition of the word insurrection. Rather, it suffices for us to conclude that any definition of insurrection for purposes of Section 3 would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking those actions necessary to accomplish peaceful transfer of power. So, the required force or threat of force doesn't have to have bloodshed, nor so they don't have to have killing people. Moreover, although those involved must be acting in a concerted way, they need to be highly organized. So it could be disjointed. We're going to call that insurrection. At its inception, insurrection may be a pretty loosely organized affair. It may start as a sudden surprise attack upon the civil authorities, community, with incidental destruction of property by fire or pillage. So the question becomes whether the evidence for district courts sufficiently established that the events of January 6th constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary. No, that's not the question. That's not the question before you. The question is whether that's what he was calling for. The whole point is, did he incite that? Was that what he was calling for? What they ultimately did doesn't matter. If they all went home, doesn't matter. That's why all the actions that happened, all the testimony from Officer Boohoo, who was crying there about, like, whatever, about how Trump needs to be tarred and feathered. That all of a sudden that's not relevant because he wasn't there. No one's claiming he was there. We have little difficulty concluding that substantial evidence in the record supported each of these elements, and that, as the district court found, the events of January 6th constituted an insurrection. That's not even relevant. It's undisputed that a large group of people forcibly entered the Capitol. Not relevant. That this action was so formidable that the law enforcement officers on site, you even recognize it wasn't relevant at the very start of this thing, could not control it. Moreover, contrary to President Trump's assertion that no evidence in the record showed the mob was armed with deadly weapons or that attacked law enforcement officers in a manner consistent with violent insurrection, district court found, and millions of people saw on live TV, recordings of which were introduced in evidence, mob was armed with a wide array of weapons. No, there was no evidence of that. There was scant evidence of that. There was a great deal of evidence that they were not armed with weapons. What are you talking about? Nor would their being armed with weapons even really be relevant, because as you said earlier, it's not about bloodshed. I thought the whole reason you brought up that lack of a need for bloodshed was, say, it doesn't matter if they were armed. Now all of a sudden you're just gaslighting at this point. Court also found that many of the mob stole objects from the court's premises. How is that relevant? Did he encourage them to do that? To use as weapons, including metal bars from police barricades, officers' batons, and riot shields. Now, throughout the day, the mob repeatedly and violently assaulted police officers who were trying to defend the Capitol. The fact that actual threatened force was used that day cannot reasonably be denied, nor would it be relevant. Substantial evidence of the record further established that the use of force was concerted and public. The district court found, with ample record support, the mob was coordinated and demonstrated unity of purpose. They marched through the Capitol building, chanting in a manner that made clear that they were seeking to inflict violence against members of Congress and Vice President Pence. And which of them were at the ellipse and heard his speech? Which of them? Any of them? Was there testimony that a single one of them was at the speech? Anyone? No. That's why none of this is relevant. Upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, reached the House and Senate chambers with minute of entering the building. Finally, substantial evidence in the record showed the mob's unified purpose was to hinder and prevent Congress from counting the electoral votes. I think that's what they were doing, yeah. As noted above, soon after breaching the Capitol, the mob reached the House and Senate chambers where the certification process was ongoing, caused the House and Senate to adjourn, put on their stupid-looking gas masks that looked like they were from, they looked like they were using, Winston Churchill's gas masks. Some of the most hilarious pictures of members of the House wearing gas masks that you ever could possibly imagine. And violence directed at Vice President Pence, who in his role as President of the Senate was constitutionally tasked with carrying out the electoral count. These actions product of President Trump's conduct in singling out Vice President Pence for refusing President Trump's demand that the Vice President decline to carry out his constitutional duties. See, this is what's so ridiculous, is you don't know that anyone who went into the Capitol was at the ellipse. Not a single person. Anyone heard him speak? So if this is what you're pinning your whole point, that he engaged in insurrection, there's no nexus. Literally zero nexus. In short, the record amply established that the events of January 6th constitute a concerted public use of force, threat force by a group of people to hinder prevent the U.S. government from taking the actions necessary to accomplish the peaceful transfer of power under any viable definition of the Constitution and insurrection. All right. So you want to label the siege of the Capitol an insurrection? I think that's a stretch. I understand how you're coming to those terms based on a very broad definition of the term insurrection. But how did he engage in it? Dictionaries all shed light on the meaning of engaged in. To begin and carry on an enterprise. Take part, participate. Okay? Stanberry's opinions mean engage, which he issued at the time the 14th Amendment was being debated. Okay? That a person may engage in insurrection or rebellion without actually having levied war or taken arms. Okay? They acted in their official capacities. So that's what the Attorney General thought? Oh, this is your fact finding that you're giving deference to her on. Okay. And I understand they have to give deference to her on these fact-finding issues. These are ridiculous fact-finding issues, but these were her findings of fact. For instance, common unlawful purpose, do overt act for the purpose of promoting the rebellion. They have engaged in insurrection. Accordingly, disloyal sentiments, opinions, or sympathies would not disqualify. When the person has by speech or by writing incited others to engage in rebellion, he must come under the disqualification. Turning to the case law construing the meaning engaged for purposes of Section 3, we found that little precedent directly on point. Case concerning treason that have been decided by the time the 14th Amendment was ratified provides some insight how the draft of the 14th Amendment would have understood the term engaged in. For example, Chief Justice Marshall explained that if a body of men be actually assembled for the purpose of effecting by force a reasonable purpose, all those perform any part, however remote or minute, they're engaging. They're considered traitors. In other words, an individual need not directly participate in the overt act of levying war or insurrection for them to hold him accountable. Okay. Not necessary to prove that the individual accused was a direct person, traitor, or violence. If he was present directly aiding, abetting, counseling, or countenancing it, he is in law guilty of the forcible act. Okay. Nor is even his personal presence indispensable, even if he's not there. He directed the act. Directed the act. Okay. Furnish the means. We find the foregoing definition of authority to be generally consistent. We believe that the definition adopted and applied by a district court is supported by a plain meaning term engaged in. Now apply it. In so concluding, we hasten to add that we do not read engaged in so broadly as to assume mere silence in the face of insurrection or mere acquiescence therein, at least absent affirmative duty to act. Rather, as Stanbury observed, apparently this Attorney General Stanbury from 1868 was like a genius, because anything Stanbury said is regarded as being like, I don't know. He's like, apparently he was the inspiration for Sir Arthur Conan Doyle's Sherlock Holmes, because whoever Stanbury says this is accurate, this is what the law is. That's what everyone in Congress meant, whatever Stanbury said. Force of the term to engage carries the idea of active rather than passive conduct, voluntary rather than compulsory action. The question remains whether the record support the district courts find that Trump engaged in January 6 by acting overtly and involuntarily with the intent of aiding or furthering the insurrectionist's common unlawful purpose. We proceed to a necessarily detailed discussion of the evidence to show why this is so. Walk us through it. Substantial evidence in the record showed that even before November 2020, the president was laying the groundwork for a claim that the election was rigged. Not relevant. You're saying he's inciting. How is this relevant? For example, August 17th. Oh, August 17th incitement. This is just asinine at this point. Moreover, when asked August 17th, only we're going to lose is if we're rigged. Oh, also on September 23rd. He wouldn't commit to a peaceful transfer of power. So obviously that's insurrection on January 6th. Despite the fact that his advisors repeatedly advised him that he lost, there was no evidence of widespread voter fraud. Oh, well, that's in your opinion. No evidence showed that he himself believed the election was wrought with fraud. That's not true. Trump ramped up his claims, plenty of evidence that he thought it was fraud. Everything he ever wrote was that there was fraud. So there's plenty of evidence that that's what he thought. Ramped up his claims the election was stolen from him and undertook efforts to prevent the certification of the election. December 13th, swing states that it found massive voter fraud, which is all of them, cannot legally certify. See, that leads you to believe that maybe he actually thought there was fraud. President Trump sought to overturn the election results by directly exerting pressure on Republican office holders in various states. On this point, and relevant to Trump's intent in this case, many of the state officials targeted by Trump's efforts were subjected to a barrage of harassment and violent threats by his supporters. So, was that the insurrection? How is any of this relevant? Why is the backdrop here relevant? This is where the left struggles with their entire amorphous thing. When you don't have if you don't have the facts, pound the law. If you don't have the law, pound the facts. If you don't have either, pound the table. That's what they're doing. They're just we're going to throw up that this insurrection, he didn't really do it on January 6th. So he really did it earlier. But earlier, nothing really happened. So we're going to take this part from here and take that part from here and hodgepodge from there and hodgepodge from here. And obviously, he's engaging in insurrection. Okay. Trump was well aware of these threats, particularly after Georgia election. We're going to talk about Gabriel Sterling. There we go. Issued a public warning to President Trump to stop inspiring people to commit potential acts of violence or someone's going to get killed. Yeah, Gabriel seemed like he was busy sucking on an egg when he was giving that stupid empty speech. Trump responded by retweeting a video of Sterling's press conference with a message repeating that very rag that Sterling warned would result in violence because Sterling's a cuck. Trump continued to fan the flames of his supporters' ire. Again, that's not insurrection. You understand what Brandenburg is, right? Which he ignited with ongoing false assertions of election fraud, propelling the Stop the Steal movement, cross-country rallies leading up to January 6th. It's kind of miraculous that he wasn't charged with incitement by anybody, ever. Specifically, between Election Day 2020 and January 6th, Stop the Steal organizers held dozens of rallies around this country, proliferating President Trump's election disinformation and recruiting attendees, including members of violent extremist groups like Proud Boys and Oath Keepers. Are they violent? When were they ever violent? When did that happen? Were they convicted of violence? Is that just did you take judicial notice of that? Where do you know that from? 3%ers, QAnon conspiracy theorists, white nationalists. It sounds like it's written by Van Jones. Stop the Steal leaders also joined 2 million MAGA marches in D.C. Okay. Relevant to President Trump's intent here. Again, as relevant to President Trump's intent here, which is hard to understand what you got so far, after November rally turned violent. Which November rally? Trump acknowledged violence, but justified it as self-defense against Antifa scum. Oh, yeah, because they attacked him. So, if you're marching peacefully and you're attacked by Antifa scum, which Antifa, you're scum. You are. You're allowed to defend yourself from someone who is attacking you. Full knowledge of these sometimes violent events, President Trump sent the following tweet on December 19th. See, this is what's so stupid. There were also violent BLM riots. Does that mean that anyone who conducted a BLM rally was engaging in some sort of, I don't know, insurrection, some sort of violence, promoting violence? This is such empty lunacy. This is where like they don't even realize how ridiculous they sound in anything that they're writing here. President Trump sent the following tweet on December 19th, urges supporters to travel to Washington. Statistically impossible to have lost 2020 election. Big protest in D.C. on January 6th. Be there or be wild. Okay. At this point, the record established President Trump's plan was that when Congress certified the election results on January 6th, Pence would reject the true electors who voted for President Biden, certify a slate of fake electors supporting President Trump, or he could return the slates to the states for further proceedings. Yeah, that was really what it was. Far-right extremists and militias such as Proud Boys, Oath Keepers, and 3%ers viewed Trump's December 19th tweet as a call to arms. They began to plot activities to disrupt the January 6th. How do you know this? How do you know this? Oh, that's what Dr. Simi claimed. They began to plan activities to disrupt the January 6th joint session of Congress. In the meantime, President Trump repeated this invitation to come to Washington, D.C. at least 12 times. Yeah, he wants people to come. It's a big rally. Biggest rally ever. On December 26th, Trump tweeted, if a Democrat presidential candidate had an election rigged and stolen with proof of such acts at a level never seen before, Democrat senators who consider it an act of war and fight to the death, Mitch McConnell and Republicans do nothing, just want to let it pass. No fight. Yeah, okay. Was that incitement? Was that incitement? Or is he urging these senators to actually, do you think he meant that they should literally fight to the death? Do you think he was saying, that Senator Schumer would come out with some sort of like mace, swinging it around? Is that what you say? Is that what you're saying he would have done? That's what you think Trump was actually saying here? Like this tweet here from December 26th actually shows that when he's saying fight, he literally doesn't. He obviously doesn't mean literally. How has anyone missed this fact? Anyone who is actually like not like so twisted with like TDS. How do you miss this? That this tweet here shows that when he's talking about they would call an act of war and fight to the death, dude, that he means that literally. You think that's what he's saying? Really? And Senator Liz Warren would come out there with her tomahawks and start woo, 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 woo. They stole the election. It's a fight to the death. Is that what people think that he was claiming here? And that similarly, Mitch McConnell should come out there with the Hatfields and the McCoys and start clicking and doing whatever the hell he would do out there in the Alleghenies or Kentucky, whatever you got out there. Is that what he thinks? I don't understand it. And on January 1st, 2021, President Trump retweeted, "How is any of this relevant?" Kylie Jane Creamer, an organizer, January 6th, and the cavalry is coming, Mr. President. Yeah, that's obviously very literal, too. It was all those freaking horses. All those horses. There was a light brigade. They were coming. This is so stupid. Oh, my God. Oh, my God. They got Corporal Agarn coming out there. They got the entire F troop coming on out there. That's what I meant. Foregoing evidence established Trump's messages were call supporters to fight, and the supporters responded to that call. And clearly, not literally. Clearly, not literally, unless you think that he's saying that he was calling for Mitch McConnell to get out his 12 gauge shotgun. In that case, he wasn't calling for supporters literally to fight either. Further supporting such conclusion was the fact that multiple federal agents, including the Secret Service, identified significant threats of violence in the days leading up to January 6th. Yeah, that's right. A lot of Antifa showed up there. These threats were made openly online. They were widely reported in the press. And yet they didn't want to have the National Guard. They didn't. Agency threat assessments thus stated that domestic violent extremists planned the violence on January 6th with weapons, including firearms and enough ammunition to win a small war. And there was none of it. Literally none of it. Sometimes I think we're living in a psyop. Along the same lines, the FBI received many tips regarding the potential violence on January 6th. Apparently, they were sometimes they were even claiming that we should engage in violence if they were Ray Epps. They think we'll have a large enough group march in D.C. armed that will outnumber the police, that they can be stopped. They believe that since the election was stolen, it's their constitutional right to overtake the government. And during this coup, no U.S. laws apply. Plan was literally kill. Please take this tip seriously and investigate further. Yet none of them brought any weapons there. I should skip this dissent. The record reflects President Trump had reason to know the potential for violence on January 6th. As president, he oversaw agencies reporting the foregoing threats. So much evidence. January 6th arrived in the early morning. President Trump tweeted, "If Vice President Mike Pence comes through for us, we win the presidency." Not relevant. All Pence has to do is send them back to the states and we win. Do it, Mike. This is time for extreme courage. Also, not encouraging violence. The obvious effect of putting a significant target on Vice President Pence's back. So apparently the incitement is that they'll take this information and that bit of information, that bit of information. We don't know that these people who showed up there had any role in any of this. At about the same time, tens of thousands of President Trump supporters gathering at the ellipse. To enter the ellipse, they're required to pass through magnetometers. Notably, from the approximately 28,000 attendees who passed through these security checkpoints, Secret Service confiscated hundreds of weapons and other prohibited items, including knives or blades, pepper sprays, brass knuckles, tasers, body armor, gas masks, baton or blunt instruments, and no guns. What does that mean? 25,000 additional attendees remain outside Secret Service perimeter. So confused who do I join? BLM, Proud Boys, Trump, congressional staffers, gay congressional staffers. Everyone wants me to fight. Hatfields, McCoy, so many choices. You can do it. You can do it. Trump then gave a speech in which he literally exhorted his supporters to fight at the Capitol, among other things. He told, did he really say fight at the Capitol? We got to get at the Harvard Nation's Capitol for one very basic, save our democracy. That's not anything. Republicans are constantly fighting, like a boxer with his hands tied behind his back. It's like a boxer. We want to be so nice. We want to be so respectful to everybody, including bad people. And we're going to have to fight much harder. Okay. Now it's up to the Congress to confront the egregious assault on our democracy. And this, we're going to walk down there, and I'll be with you. That's not fighting. We're going to walk down the Capitol. We're going to cheer on our brave senators, congressmen. We're probably not going to be cheering so much as some of them, because you'll never take back our country with weakness. You need to show strength, and you have to be strong. So he's talking about the congressman there. What the hell are you even talking about? When you catch somebody in a fraud, you're allowed to go by very different rules. Okay. What does that mean? This is the most corrupt election in the history, maybe in the world. This is not just a matter of domestic politics. This is a matter of national security. When you fight like hell, if you don't fight like hell, you're not going to have a country anymore. That's the one quote that they have. Where's the peacefully and patriotically? Where's that part? Crowd of lips react to President Trump's words with calls for violence. Did they? Members of the crowd shouted, "Storm the Capitol." How many? Like some knucklehead in the back, probably a glowy, screaming, "Storm the Capitol! Invade the Capitol building, take the Capitol!" Before he even included his speech, President Trump supported follows instructions. So then how did he direct them if it's before he included his speech? Oh my God. Oh my God. Crowd marched to the Capitol, many carrying Revolutionary War flags, Confederate battle flags. That's a crime right there. Quickly breached the building and immediately advanced to the House and Senate chambers. This is so stupid. This is just stupid. Rather than taking action to end the siege, however, approximately 1 hour later, Mike Pence didn't have the courage to do what he should have done to protect our country. The Constitution giving states a chance to certify a correct set of facts, not the fraudulent and inaccurate ones they were asked to previously certify. USA demands the truth. Okay. So he's saying it's over. It's done. He didn't have the backbone. Tweet was read over bullhorn to the crowd at the Capitol. Produced further violence. Really? Did it? And he knows it's going to happen? How is he supposed to know that's going to happen? President Trump's next public communications, 238 and 313, encouraged mobs to remain peaceful. Stay peaceful. I said mob was not at all peaceful. No, they were very, very peaceful. 95% of them were peaceful. 5% were not. Not at all peaceful. Neither tweet condemned the violence nor ended the mob. This is so stupid. This is just like, this is comical. You're a joke. Colorado, you're a joke. Your judiciary is a joke. It's run by the highest clowns in the land. You're a joke. Throughout these several hours, Trump ignored pleas to intervene, instead called on senators. That's not in. Where is inciting? God, this is so stupid. Finally, at 4:17 p.m., President Trump released a video urging the mob to go home now. A short while later, Trump reiterated his support message to the mob by justifying his actions. No. So is that incitement at that point? Is that incitement after the fact? Is that what it was? Is that engaging? Is that giving comfort? Is that what he was doing, giving comfort? We include the foregoing evidence that the great bulk of which was undisputed trial established that Trump engaged in insurrection. You decided that before. You decided that 3 years ago. You literally decided that 3 years ago. Trump directed and expressed efforts over several months, exhorting his supporters to march to Capitol, which that's not engaging in insurrection. To march to Capitol, that's all free speech. Are you going to address free speech? Well, he engaged in insurrection because engage does not include incite. Well, he didn't even incite. We disagree with Trump's contention. His record does not support finding engaged in insurrection because engage does not include incite, deny the requisite intent to aid or further insurrection's common unlawful purpose. Did not merely incite the insurrection. Really? Did you read Brandenburg? Maybe this is why you shouldn't handle federal questions of law, because you can't even figure out what Brandenburg says. Even when the siege in the Capitol was fully underway, it continued supported by repeatedly demanding Vice President Pence refused to perform his constitutional duty by calling senators to persuade them to stop the count of electoral votes. He specifically told them to remain peaceful over and over again. He told them to march down there peacefully. So, yeah. But you left out march peacefully and patriotically. And exhort them to fight to defend the certification 2020 presidential election. You're a freaking joke. You're literally a joke. All right, here we go. Free speech. Free speech. We're gonna get to Brandenburg. Let's go. Let's ignore unprotected First Amendment. Here we go. Standard of review. We're going to take the independent review of the record to be sure the speech's question actually falls within an unprotected category of communication. We're doing this de novo. So this is our own stupid findings that Brandenburg doesn't apply anymore. First Amendment protection and incitement. First Amendment of the United States provides that Congress shall make no law abridging freedom of speech. We want to punish him for his, so let's figure out how to bend that around. The right of free speech is not absolute at all times and under all circumstances. Yeah, we know this. This is all stuff you learned in your first year of law school. That Supreme Court explained in Brandenburg. Here we go. First Amendment's constitutional guarantees free speech, not permit a state to forbid or prescribe advocacy of the use of force or law of the use of force. Oh, you mean you could say fight under Brandenburg? Wow. I thought Brandenburg outlawed saying fight. You can say fight? You can say fight? Who knew that? Except where such advocacy is directed to inciting or producing imminent lawless action is likely to incite or produce such action. Under Brandenburg and its progeny, modern tests determine whether speech is unprotected under the First Amendment because it incited lawless actions, whether the speech explicitly or implicitly encouraged use of violence or lawless action, and the speaker intended the speech would result in the use of violence. And the use of violence or lawless action was the likely result of the speech. Trump contends, which, by the way, this is not good about Trump, which Trump won that case. But we're going to pretend that didn't happen either. We're going to pretend the Sixth Circuit didn't say that. Yeah, he was fine. Now, that case was someone he said was someone, they took someone out and beat him up. Trump contends that the district court erred by examining the broader context in which President Trump's speech was made, thereby expanding the context relevant to Brandenburg analysis beyond anything recognized in precedent. He asserts we should examine his speech only in the narrow context in which it was made. Kind of like Brandenburg says, immediately, imminently. We disagree. Schenck v. United States Supreme Court addressed for the first time advocacy of illegal conduct. What? And this is, when was Brandenburg? What year was Brandenburg? 1960. Wait, what year was Brandenburg? $1969. Okay. So we're going to go 50 years earlier to 1919 to figure out how to read Brandenburg. Okay. Schenck v. United States. Supreme Court addressed for the first time the advocacy of illegal conduct, and it recognized the importance of context and holding the character of every act depends upon the circumstances in which it is done. Although the Supreme Court has said little about how to analyze incitement since Brandenburg, it offered some guidance regarding the court's use of other statements of context in NAACP versus Claiborne. At least this is something that was applying Brandenburg. In Claiborne, court considered speeches given by Charles Evers, field secretary of Mississippi NAACP, in connection with the NAACP's boycott of white merchants in Claiborne County from 1966 to 69. Evers declared to black residents in Claiborne County that blacks who traded with white merchants would be answerable to him, and that any Uncle Toms who broke the boycott would have their necks broken by their own people. Evers' statements also included that boycott violators would be disciplined by their own people. He warned that sheriff could not sleep with boycott violators at night. County held that Evers' speeches were protected by the First Amendment. Oh, okay. But said if there was other evidence of Evers' authorization of wrongful conduct, the references to disciplined speeches could be used to corroborate that evidence. By considering placing value in the absence of corroborating evidence of Evers violating, I gotta scratch my chin, reaching over my head. That's the easiest way for me to scratch my chin if I'm on the Colorado Supreme Court, because this is where my scratch. It's very itchy right here by my chin. I actually picture these chief justices like biting on their own hair as they're thinking through how to write this crap. By considering placing value in the absence of corroborating evidence and Evers, they implicitly said the courts may look to circumstances beyond the speech self-determined intent. Okay, but you're not counting that as part of the incitement. You're not counting that as part of the incitement. Even if you could, even if that's true, even if everything you're saying is true, that's not part of the incitement. That's part of the speaker's intent. So that might help us figure out what Trump wants, assuming that you could read any of that to say that he wants there to be violence. That's it. But not that now leads to follow-up statements now becoming incitement much quicker. No. This is so stupid. While incitement precedent is sparse, the case law on true threats is instructive regarding the importance of context. True threats and incitement are doctrinally distinct. Okay. But true threats are the closest cousin to incitement under the First Amendment. Oh, God. The line between two forms of speech, incitement and true threats, may be difficult to draw in some instances. So they're really very different, but we're going to pretend they're the same. We're trying to come up with some sort of basis here to ignore Brandenburg. Multiple federal circuit courts, including true threat analysis, confirm what common sense suggests. When assessing whether someone means to threaten another with unlawful violence, you sometimes need to consider more than the behavior exhibited on one occasion. Again, all this would tell us is his intent, and nothing in his prior speeches. You see, here's the thing. This is where they play a shell game with these earlier tweets, because they try to basically say that these earlier tweets were riling the base, go after Pence, terrible, evil, terrible Pence. I'm going to trick you into thinking that they're lying. I'm going to trick you into thinking that this was stolen. I don't think it was stolen, but I'm going to trick you into thinking it was stolen so I can get you to act violently on my behalf. To basically say and then he said, come, it's going to be wild. What's the purpose here? When you're reading all those tweets in the backdrop here, the backdrop is, and this is an important thing, so I'm going to just sort of close this for a moment so you can make sure I have your focus, and I'll be able to find it easier later when I'm trying to figure out, oh my God, that was 5 hours and 13 minutes into this thing. There's different elements here as to what they're playing a shell game. The court here is playing a shell game with respect to the backdrop of the earlier statements and tweets and actions by Trump leading into why that's relevant to what happened on January 6th. Because there's two things that they're looking for. The problem they have is they need to establish that there's a shortness in time, and a direct statement, he's directing them to do something imminently unlawful. That's what incitement is. And the problem they have here is you have to show that he has an intent for them to do something unlawful, and then you have to show that these words would reasonably lead someone to doing something unlawful. So you have two different things here. You have the speaker, and then you have the listeners. So what they're saying is, well, we have a right to, we're going to tell you all about the backdrop here. Do you know what he was doing? For months, even before the election, he's like, I don't know if I'll trust the legitimacy of the election. I don't know if I'll trust the outcome. He's sending out tweets saying, like, I'm not sure that everything here is going to be above board. And then he's complaining about the election, even though, he doesn't. And he says, come. 12 different times he's sending out tweets saying, come, it's going to be wild. 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 Think as we're hearing these tweets, is this telling us about his state of mind? That he wants something unlawful to happen? Or is this about riling up the crowd and prepping them so that they're on a powder keg? That the moment you say the word, you don't say anything, you just have to say, go, and they're going to go and do something violent. Because these are two different things. And what they did was they gave you all this background to lead you into this is how he tricked and duped millions of his supporters into this frenzy where they believed his lie, and they're violent people, they're oath keepers and 3%ers and QAnon and crazy conspiracy theorists who are armed to the teeth. And why are they armed to the teeth? Because he's goading them and 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 goading them. And this is all the different evidence we have that he's goading them and goading them. Is that relevant to what happened on the day of? That they're all goaded and riled up? No. The only reason it's relevant is to basically tell us what is his mindset, what his thought process is, not what the speakers, not what the listeners' mindset is. So they play this shell game where they're like, here's all the stuff he did to rile up these folks. Does that tell us that he didn't actually believe all this crap? No. That's not crap, by the way. He didn't believe all the stuff he was saying. Doesn't tell us anything. They're making that assumption about him, that he's completely full of garbage. But I'll tell you right now, if you know anything about Donald Trump, and you think he genuinely believed in his heart of hearts that he lost, you're an idiot. Because there's no way that man thought he lost. There's no way. The left should know better than anyone that he's in his own brain. There's no way he accepted that he lost. So no, he's not trying to. It's not that he's intentionally lying to them. Maybe he's deluded. In best case scenario, from perspective of the left, he's crazy deluded, but that doesn't mean he doesn't genuinely believe it. But they're sitting here lying in this decision here, saying that he knew that this was all that he lost. He knew. But he had the purpose of trying to stop the peaceful transfer of power. That's the crime that he's trying to commit, or trying to engage in some sort of violence in order to stop this peaceful transfer of power. That's the crime he's trying to engage in here. But the point is, none of his words could possibly be used to mean incitement of go commit a crime. He says, we're going to go fight. I mean, that sounds like a joke. That doesn't sound like a joke unless you give some sort of credence to the backdrop and somehow even take those and exponentially increase them 47 times to basically say, so that's what's leading towards them engaging in violence. But you can't use it for that purpose as far as the impact on the listener. You can only use it to give evidence as to what he's thinking, not the impact on them. But that's the shell game that they're playing. The shell game they're playing is, they were ready to go because of him. Doesn't matter if they're ready to go because of him. Doesn't matter. It's not part of Brandenburg. Multiple circuit courts conducting a true threat analysis confirm that common sense just assessing someone means to threaten another with unlawful violence sometimes need to consider more than behavior exhibited on occasion. This is the actor, not the listener. They're so desperate. This is not to say President Trump contends the court found that we may consider any speech ever uttered by Trump in evaluating assignment. Of course, there are limits. Really? What? Like his wedding vows? How far back can you not go? We need not define those outer limits now. Instead, we simply conclude that it was appropriate for the district court to consider Trump's history of courting extremists. Why? Why would it matter who he's courting? Endorsing political violence. He didn't endorse political violence. It's legitimate and proper. Even that's ridiculous. To undermine the legitimacy of the 2020 results. With this in mind, we review the district court's application of Brandenburg's three-pronged test. First prong of the test of assignment is not the speech expressly or implicitly encouraged use of violence or lawless action. District court made dozens of findings regarding the general atmosphere of political violence that President Trump created before January 6th, many of which were already outlined in discussing why the district court concluded that Trump engaged in insurrection. We incorporate those observations here by reference and supplement them with illuminating evidence from the record below. For example, district court found that at February 2016 rally, Trump told his supporters that in old days, protests would be carried out on a stretcher. This is so stupid. This is just like, it's hard to believe they actually mean this seriously. This is just ridiculous. During the 2020 election, it's like, what makes you think anybody at the Ellipse knew of any of these incidents? The district court also credited the testimony of Professor Peter Simi. My God, that guy was a joke. So, professor of sociology, Chapman University, who it had qualified as an expert, which that sounded like a joke when he did in the first place, how extremists communicate and how the events leading up to including January 6th attack relate to the long-standing patterns of behavior. Violent far-right extremists understood that Trump's calls to fight, which most politicians mean only symbolically, when spoken by Trump, literal calls to violence by these groups, which is completely not within what Brandenburg allows for. See, that's the effect on the listener. You cannot account for that under Brandenburg. This is such a gross application. This is so stupid. You guys want me to just jump ahead? Because I'm really getting tired of reading this idiocy. This is so stupid. Should I jump ahead to the dissent? Let me see what you're saying here. I'm gonna check out in locals. What do you guys want me to do? You want me to jump to the dissent? Fan says Joe POTUS loves to punt when they will take easy way out, same as text versus pay. Oh God, this is so. Yes, they could punt. Colorado Supreme Court said they were deciding this case de novo. They don't have to look at the underlying cases. Signing new, they can do their own fact finding. That's not on issues of fact, and that's why I found that section. All right, I think it's time to jump ahead. Let's jump ahead because this is mind-boggling stupidity. I mean, when they're quoting Simi, I just can't. See, look for some more control. Someone said some more is this was what was recommended to me. So we're gonna. Apparently, it wasn't even that far ahead of where I was. Like only 20 pages down. How long is this? Now it is undoubted that these provisions of the Constitution, which deny the legislature power to deprive any person of life, liberty, or property without due process of law, or to pass a bill of attainder or any ex post facto, are inconsistent with the spirit and general purpose with the provision which at once without trial deprives a whole class of persons of offenses for cause however grave. These astute words uttered by U.S. Supreme Court Justice Salmon P. Chase a century and a half ago eloquently described one of the bedrock principles of American democracy. Our government cannot deprive someone of the right to hold public office without due process of law, even if we are convinced that a candidate committed horrible acts in the past, dare I say, engaged in insurrection. There must be procedural due process before we can declare that individual disqualified from holding public office. Procedural due process is one of the aspects of American democracy that sets this country apart. The decision to bar former President Trump, by all accounts, the current leading Republican president candidate from Colorado's presidential primary ballot, flies in the face of due process doctrine by concluding that Section 3 of the 14th Amendment is self-executing. The majority approves the enforcement of that federal constitutional provision by our state courts through the truncated procedural mechanism that resides in our state election code. Thus, based on the interpretation of Section 3, our court sanctions these makeshift proceedings employed by the district court below, which lack basic discovery, the ability to subpoena documents, compel witnesses, workable timeframes to adequately investigate and develop defenses, and the opportunity for a fair trial to adjudicate a federal constitutional claim, masquerading as a run-of-the-mill state election code claim. Because most other states don't have election code provisions, we do. The election code provisions we do. Thanks for your blessing, brother. They won't be able to enforce Section 3. That, in turn, will inevitably lead to the disqualification of President Trump from the presidential primary ballot in less than all 50 states, thereby risking chaos in our country. This can't possibly be the outcome of the framers intended. I agree that Section 3 bars public office anyone who, having previously taken an oath in office in the United States to support the federal Constitution, engages in insurrection. But Section 3 doesn't spell out the procedures that must be followed to determine whether someone has engaged in insurrection after taking the prerequisite oath. That is, it sheds no light on whether a jury must be impaneled or bench trial will suffice, proper burdens of proof, standards of review, application of discovery and evidentiary rules, or even whether civil or criminal proceedings are contemplated. This dearth of procedural guidelines is not surprising. Section 5 of the 14th Amendment specifically gives Congress absolute power to enact legislation to enforce Section 3. My colleagues in the majority concede that there's currently no legislation enacted by Congress to enforce Section 3. This is of no moment to them, however, because they conclude that Section 3 is self-executing and that the states are free to apply their own procedures. Everyone just do whatever the hell you want, including compressed ones and an election code to enforce it. This is hard for me to swallow. Significantly, there's a federal statute that specifically criminalizes insurrection and requires that anyone convicted of engaging in such conduct be fined or imposed and be disqualified from holding public office. If any federal legislation arguably enables the enforcement of Section 3, it's Section 2383. True, Trump has not been charged under that statute, so it's not before us. But the point is that this is the only federal legislation in existence at this time to potentially enforce Section 3. If Trump had been charged under Section 283, he would have received the full panoply of constitutional rights that all defendants are afforded in criminal cases. So if there's a criminal case here, he would have had a chance to defend himself. More to the point for our purposes, had he been so charged, I wouldn't be writing separately to call attention to the substandard due process of law he received in these abbreviated election code proceedings and how crap our own Colorado judiciary is. I recognize the need to defend and protect our democracy against those who seek to undermine the peaceful transfer of power. Meaning, I don't like Trump either, and I think that's what he did. And I embrace the judiciary's solemn role in upholding and applying the law. But the solemn role necessarily includes ensuring our courts afford everyone who comes before them in criminal and civil proceedings alike due process of law. And you basically rob the dude. Otherwise, it's relevant here. How can we be confident that someone who's declared ineligible to hold public office pursuant to Section 3 actually engaged in insurrection or rebellion after taking the prerequisite oath? In my view, no, stop at the double jeopardy. Stop. It's not double jeopardy. Stop. No. It's never double jeopardy. I feel like Sherlock Holmes. Maybe it was twins. It's never twins. Okay? It's never double jeopardy. Anytime you think it's double jeopardy, trust me, it is not double jeopardy. It's just not. So as the dissent continues, in my view, what transpired in this litigation fell woefully short what due process demands, because I perceive the majority's ruling that Section 3 is self-executing to be the most concerning misstep in today's lengthy opinion. I focus on that aspect of legal analysis. Context is key here. The 14th Amendment was designed to address a particular juncture in American history, namely the Civil War. The Civil War. The postbellum framers were confronted with the unprecedented nexus of historical events that gave rise to and shaped secession, the Civil War, and Reconstruction. And their response, in some measure, sounded the clarion call of a constitutional revolution. Indeed, the 14th Amendment ushered an expansion of federal power that undercut traditional state power. Forefront in the minds of the framers were the evident concern that the states would again seek to undermine the national government, which is ironic now that those amendments are now being used by a state to undermine the federal government. In short, the states, state institutions, state officials, state courts were not to be trusted. And here comes along Colorado saying, to hell with you, United States Congress. We're deciding where the 14th Amendment goes. According to this, this is such a great point that Samur is making here. Such a great point. Such a great point. Oh, my God. According to the interpretation of Section 3 of the 14th Amendment that the Colorado court is making here, the southern states would have had the power to declare that Ulysses S. Grant engaged in insurrection when he came marching on through the South and accordingly was ineligible to run for presidency. Think of how stupid that is. That a state has that unique individual power. So all of a sudden, South Carolina be like, oh, no, we're not having, Grant can't get on the ballot here. He's Section 3 of the 14th Amendment. He engaged in insurrection. Get him off. We're not letting him on the ballot. State power is plenary. That's what our state says. Not just Sherman. Grant also was great holy bat ears. Magliacca. I know Sherman's the one who marched down to Georgia. My point is that Grant fought against the South also. And he ran for president. What would have stopped South Carolina from saying, oh, he engaged in insurrection. He fought against us. So we're not allowing him on the ballot. What would have stopped him? Thus, the indelible trespass of the former Confederate states was met squarely by an overreaching goal to render federal institutional authority paramount. Such is the contextual framework informing my view by the instant matter. To my mind, it compels a conclusion soundly supported by the framers' intent and the way the relevant authorities that Section 3 of the 14th Amendment is not self-executing and that Congress alone is empowered to pass an enabling legislation, not some stupid individual state. My colleagues in the majority turn Section 3 on its head, hold that it licenses states to supersede the federal government. This is such a brilliant point. I tip my cap to you some more. I didn't even think of this one. Respectfully, they have it backwards because no federal legislation currently exists to power Section 3 and propel into action because President Trump has not been charged under Section 2383 and because there's absolutely no authority permitting Colorado state courts to use Colorado's election code as an engine to provide the necessary thrust To effectuate Section 3, I respectfully dissent. I would affirm the district court's judgment in favor of President Trump, but I would do so on other grounds. The district court. How long is this? Oh my gosh, is this going to go for a long time? This looks like it goes for a while. All right. I think we've absorbed enough for one night. Do you think we covered enough? I think we covered enough for one night. I think so. I'm going to go through this and see whether I might cover this on locals tomorrow, the balance of this, or the important parts of this. I think that's the way to do this. I think that's the way to do this. Yeah, that's how we're going to do this. All right. I'm going to be wrapping up here because I'm feeling like I'm losing my steam. If you're on Rumble and you can help push me up to 10,000, I need like 230 of you to sign up. It shouldn't be that hard. It's 420 you watching. So if you could do that, that'd be most appreciated. Eventually, I'm going to hit 10,000. You would think, right? It's got to happen, right? Eventually. While you're here on YouTube, if you could like and subscribe, whether you're watching my main Good Lawgic, you're watching the Trump Trial channel, I appreciate you joining me here this evening. I really do need to close this thing down. I didn't even end up eating supper tonight. So thank you all for joining me. Tomorrow at some point, I probably will cover more of this on locals. That's probably what's going to end up happening. But it's gotten late. I just realized it's freaking 1:20 in the morning. What's Tim Pool? Is he going to get me on? Is Tim Pool really getting me on? All these people talking about Tim Pool. Yeah. All right. I'm going to grab some cough medicine. Thank you all for joining me. I'm gonna look through these dissents. I think they're gonna be a lot of fun. What I need to remind you is don't let this case bother you. At the end of the day, these decisions against him, all these moves by the radical left, they just make the movement stronger, 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 stronger. If you really want to be strong, though, remember, you have to be happy, eat some bucks. As always, my friends, Godspeed.